It's upon notice, Lordship. It will appear as application. Yes, yes.
My lord, may I bring leave for filing, my lord, the word very urgent, my lord, circuit bench matter, my lord. The matter, my lord, FR, my lord, 12, my lord. Only, my lord, bring leave for filing. 12, my lord. Subsequently, my lord, some difficulties, my lord, the not file in the within the period, my lord. But now, my lord, the circuit bench is sitting in there. But this is due to FR, my lord, that's file. I want to file before this court, my lord.
I cannot understand.
But this is, my lord, at present, the circuit bench is running in Andaman, my lord.
Yes.
But this matter was FM on 12. That's why I'm not unable to file before the, my lord, that court, my lord. So I am taking leave to filing before this court, my lord.
Before this court, but then there is a circuit bench.
But this is, my lord, that matter was filed in long back in the, my lord, FM on 12 September. That's why, my lord. But not.
You please go before the circuit bench. You can't file it here.
My lord, this is, my lord, already FM, my lord. That's
Maybe,
why.
but then you have to go before the circuit bench.
My lord, 29th, my lord, the last date
You
of.
could not have. You have affirmed it on 12th. You come today. Then you mention it. You have to go before the circuit bench.
Great.
May I please your lordship to mention a matter? My lord, this is a new motion, my lord.
All right. Upon notice.
Yes, my lord.
May I have my lord's kind leave, my lord, to mention, my lord, that hearing matter, my lord, regarding the employees of Barnes
No,
Standard.
not now. Please mention after the vacation. It is not possible. Please look at the list and you see the number of new motions on the list.
Lord, item 1, Lord, I am appealing for the private respondent number 5.
I am appealing on behalf of the
The
petitioner.
maintainability issue.
Maintainability issue, there is the point.
Number 3.
Lord, so far as the maintainability point is concerned, my lord, I have gone through, my lord, the St. Mary's judgment. My lord, it is applicable to my case. My lord, this is the judgment, if your lordship kindly can. My lord, it is reported at 2023, volume 4, SEC 498.
Yes.
My lord, I will be relying on, my lord, only the last paragraph, my lord, which is the, my lord, page 537,
Yes.
paragraph 75. My lord, all the paragraphs are not relevant, but my lord, may I just indicate few paragraphs, my lord, from paragraph 75.
Yes.
My lord, may I just read, my lord, 75.2 onwards, because this is relevant. Because my lord, initially my submission was, this is a absolutely private institution, doesn't receive any kind of grant from the state. And my lord, in the earlier occasion, your lordship's query was whether the DA component, my lord, whether state has any kind of contribution or not. My lord, I have checked up, my lord, there is no contribution at all. My lord, we used to pay DA, my lord, from the fund, my lord, receive, my lord, out of, my lord, the admission fees. That is all. Now, lordship may kindly come to, my lord, 75.2. Even if it be assumed that an educational institution is imparting public duty, the act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers a right upon the aggrieved to invoke the extraordinary writ jurisdiction under Article 226 for a prerogative writ. Individual wrongs or breach of mutual contracts without having any public element as its integral part cannot be rectified through a writ petition under Article 226. Wherever courts have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by the statutory provisions or the employer had the status of state within the expensive definition of Article 12, or it was found that the action complained of has public law element. Now, lordship kindly consider 75.3. This is very relevant. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the power of the High Court conferred by Article 226 in respect of matter relating to service where they are not governed or controlled by the statutory provision. As educational institution may perform myriad functions touching various facets of public life and in the societal sphere, while such of those functions as would fall within the domain of the public function or public duty be undisputedly open to challenge and scrutiny under Article 26 of the Constitution. The actions or decisions taken solely within the confines of an ordinary contract of service having no statutory force or backing cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In the absence of the service condition,
75.4,
Lordship,
the line started with.
even if it is perceived that the imparting
The
education,
line starting with 8 in any case.
my lord. In any case, the terms of employment of contract between a school and non-teaching staff cannot and should not be constituted to be an inseparable part of obligation to impart education. This is particularly in respect to the disciplinary proceedings that may be initiated against a particular employee. It is only where the removal of an employee of non-teaching staff is regulated by some statutory provisions, its violation by the employer in contravention of law may be interfered with by the court. But such interference will be on the ground of breach of law and not on the basis of interference or in discharge of public duty. Now, Lordship, kindly consider 75.5. This is the last paragraph, my lord, I will be reading. From the pleadings in the original writ petition, it is apparent that no element of any public law is agitated or otherwise made out. In other words, the action challenged has no public element and writ of mandamus cannot be issued as the action was
So
essentially.
the question is whether the person concerned, whether the employee concerned is anyway related to discharging of public function or not. So if it is, suppose that it is a cleaner in an educational institution or a cleaner in a bank, a group D staff. Now that person cannot be held to have a direct nexus with discharging of the public law function of that institution. A teacher of an educational institution will have a direct nexus with the functioning of the or discharging of the public law duty of the institution.
Milord, with regard to this, Milord, may I just humbly submit one thing? Milord, similar kind of, as your lordship, Milord, disclosed in respect of Milord, banking institution, Milord, it was relied on, Milord, the earlier decision, St. Mary's judgment has taken care of. Milord, regarding this, Milord, may I just humbly indicate one thing? Milord, this is a purely contractual service. Milord, there is a terms and conditions specified, Milord, under the agreement, Milord, what they have to follow. Now, Milord, with regard to, Milord, the element of public duty, Milord, they are stating that as per the Act, Milord, the institution is controlled, Milord, only with regard to syllabus and, Milord, with regard to imparting education, any kind of, Milord, element.
This is a
Milord, only
college. It relates to discharge of public duty in terms of providing education. Now, this is not a disciplinary action between the lecturer and the college. It is for payment of his salary or his emoluments.
Yes.
The question is whether the government policies will be applicable to this
Yes.
college or not, as far as the pay is concerned.
Grateful, Milord. Milord, that is the only question. Now, Milord, alternatively, Milord,
This is not a question of a disciplinary action relating to only service contract between this person and the institution.
Milord, this
So
person.
there are three elements in that paragraph.
Well-
First, direct nexus with discharge of public duty. Second, whether it is a service contract relating to disciplinary action. Third is whether the person concerned is directly discharging the public duty.
Milord, so far as this point is concerned, Milord, may I just humbly submit? With regard to, Milord, their emoluments are concerned, Milord, they are not discharging their duty since 2019, although they are receiving, Milord, wages. Milord,
That
they
is
are,
on
they are,
merits. I
that
cannot
is on
go
merit.
into
Milord,
that.
I am
No,
not
that is
entering
on
it.
merits. Now you submit on the maintainability point first.
Milord,
I will
regarding
only get into
maintainability,
the merits once the maintainability issue is.
Milord, may I just indicate, Milord, few paragraphs from their petition itself with regard to maintainability. Because, Milord, from the petition, Milord, what they have sought for. Lordship, kindly see their prayer portion.
Mr. Shaw, you consider this judgment?
Yes, your lordship. Yes, your lordship.
Yes.
Lordship, may kindly have a look to, Milord, page 22 onwards, their prayer portion. Milord, I am not reading the entire paragraph, but, Milord, the sum and substance, Milord, may I just indicate. Milord, paragraph A, Milord, with regard to, Milord, taking action against, Milord, not allowing, my lord, to continue with their normal duties. This is, my lord, prayer A.
Direct nexus with public
My lord,
function.
with
They are
regard to this,
lecturers.
my lord, with regard to this,
It doesn't fall under a service contract or a disciplinary action.
my lord, with regard to this, we have already issued show cause notice to them. My lord, although it is after post filing, my lord, after, my lord, filing of the writ petition.
Nothing, neither here nor there.
No. Now, lordship, kindly see, my lord, paragraph, my lord, prayer B. My lord, this is with regard to, my lord, taking steps, my lord, for not operating, my lord, the institute as per the norms fixed by the AICT. My lord, my humble submission is, my lord, with regard to this, my lord, petition is not maintainable because they are
These
agitated.
are for release of areas of salary, and they are doing public function. They are discharging. Their function is in direct nexus with the discharge of public function. It cannot be held to be a service contract between the college and the employee. Anyway, let him consider the decision. Why am I
Lordship.
fighting his case? He will
Lordship.
come back.
Yes, your lordship.
Asha. Mr. Chakraborty, learned counsel, appearing on behalf of the respondent number 6. Submits that the salaries and emoluments to be paid to the petitioners are governed by private contracts between a private educational institution and the petitioners. Full stop. There is no direct nexus with discharge of public function stroke duty. Full stop. Therefore, comma, even if the educational institution is discharging a public duty, comma, the petitioners cannot get any relief under Article 226 of the Constitution of India. Full stop. Next, let the matter appear for further consideration under the same heading motion hold on October 9, 2023. So, you are appearing for the bank?
Yes.
Yes, please. Please speak on the microphone. Yes.
The petitioner was an employee of the STL United Bank of India. Now, because of amalgamation merged with the Punjab National Bank, he underwent surgery of system hydrocele, and thereafter he was having post-operational difficulties and he was experiencing difficult to perform duties in the bank. He submitted representation request for voluntary retirement, but such request was rejected. He submitted application for transfer to Mumbai, where he was undergoing treatment, and his ailing wife also resigning. Such request was turned down. The petitioner was constrained to submit resignation, which was duly accepted by the bank. There, the bank introduced a scheme called another option to join pension scheme under the United Bank of India. Said scheme was circulated violated 20,000. The petitioner submitted representation to 6/10/2000 for allowing pension. As another option, second option, the petitioner had annexed with the presidential solemn order passed by the Honorable Divisional Bench Calcutta High Court. The mechanically, without application of mine, rejected the representation. There, the petitioner submitted another representative 5/6 to Punjab National Bank. Said representation was also rejected by the Punjab National Bank. Hence, this representation. Now, I will come to paragraph 4 of the
Paragraph
4.
that is not relevant. Please take me to the scheme.
Scheme, my lord. But before scheme, my lord, I may permitted to file a circular by the Indian Banks Association, which is binding. I'm giving to my learned friend. After paragraph 2, my lord, after holding various rounds discussing the matter, consensus arrived at between the parties on the bipartisan settlement joint note. So we have extended who were in service of the bank on 20 September 1995 in case of
My lord,
nationalization.
before he starts his to delay the matter, my lord, this circular, it relates to the workman. It does not relate to the officer. He was a bank officer, law officer.
It says compulsorily retired officers stroke employees. That's the subject.
Yes, no,
Please look at the subject of the circular.
agreement.
Yes,
Not agreement, the circular, the subject.
After holding various,
Dear sir, madam, just after that.
that is the settlement.
He's resigned. He's not his compulsory retired officer. He's not some resigned retired.
My lord, he's a retired person, not retired person. He has resigned from the organization. So this is not applicable in that context also. Apart from this, I have given this, he is not in a workman capacity.
No, this is applicable for the officers, not workmen.
Those words taken.
Retired.
Yes, retired.
He is not
employees
retired.
And officers, yes.
Yeah.
Page 126.
Well, kindly turn to a page 126.
What?
26.
126.
Your 126.
yes.
Page.
Page 126.
Page 126.
This is the reason order.
We have passed the reason order this way.
This was passed by the PNB, the National Bank. জানে বললাম আপনারা তো বলতে হবে সব জানে না বলতে চুপ করে বসতে হবে
বলে দিচ্ছি তো, করে নিন।
In this context, my respective submit, my lord, when the scheme has been examined by the Honorable Division Bench, the scheme is judgment delivered by the Honorable Division Bench, is judgment in rem, not judgment pass.
Show.
My lord, that is at page 106. My learned friend appear in that as well.
Yes, I have distinguished that also with this matter.
It starts from age 110 is the, my lord, reader person. 110, my lord.
We have 16 years.
বলুক না ওরা বলো।
Supreme Court. Target division. Swapnara division wise, sir. Swapnara division wise. Swapnara.
Yes,
Well, dear my lord, page 110016, page wise of the judgment, my lord.
yes.
My lord. Well, another case, my lord, that
I'll hear this matter as 4 orders. I'll hear this matter as 4 orders. I'll keep this matter as 4 orders and I'll hear this matter as 4 orders. The only issue is whether you can consider his resignation as voluntary retirement or not.
16 years delay bolo.
16 years delay. 16 years delay
What delay?
for filing this petition.
Yes,
From
resign in year
Resigned in 2007.
Yes, the scheme has come. After that, he has made representations to you.
Then when he was not in employment at that point
Yes.
of time. And moreover, he was the officer category and he was the,
and
that
2013
other
was
case
That circular that he is referring to relates to
page 105 please.
105.
relates to officer category.
Yeah.
We have to look into the letter and spirit of the order.
105 to
The spirit of the order says that just prior to once he has completed qualifying service, the question is whether or not his resignation can be treated as voluntary retirement. The facts of the case shows that this petitioner is better placed because he has already prayed for voluntary retirement,
my lord,
which was not accepted by the bank. In the division bench's judgment, the resignation letter was very cryptic and he did not pray for voluntary retirement. Facts of the case show that this petitioner is better placed.
But not from the earlier one. My earlier one, they have relied upon the bipartite settlement. He's not covered by the bipartite settlement.
Whatever it is, he has prayed for voluntary retirement.
My
you
lord,
did not
kindly
accept.
allow me to
Prayed
file
for- prayed
to
for,
distinguish this. My lord, it is a very serious case. To distinguish, I'll file my repetitive in opposition. I'll narrate out it.
First, I will, you submit. Because if I give
Because
you
his
directions for
qualifying
filing of
service
affidavit in
not less than
opposition,
30
it will
years.
take a
That's there
long
is not
time.
My lord,
What do you
his
want?
qualifying service is not less than 30 years. That is the difference.
Bring in a report on affidavit. You file a report on affidavit. Asha.
I'll file a report in my video.
Yes.
That's all.
The petitioner's case is that he is eligible to opt for pension under the pension scheme of United Bank, erstwhile United Bank of India, within bracket UBI, bracket close, comma, now merged with Punjab National Bank, PNB, bracket closed.
My lord, before your lordship conclude, my lord, only consider page 80. Page 80 of the writ petition.
Page,
80.
all right. I shall. Such scheme was circulated by a letter dated August 20, 2010. Full stop. Next. 20,
After
2010.
80 বলে কি সাথে?
The
Sarah,
petitioner made a prayer for
তাও বলেছে আমাকে বলতে।
voluntary retirement from service
Madam, I have already referred to your lordship in the argument. I am sold from the paper.
Such prayer was turned down, full stop. Next, he made a prayer for transfer to Mumbai on August 8, 2007, full stop. Such a prayer was also turned down by the bank, full stop. Next. We made a prayer for voluntary retirement of service on August 19, 2007. ওটাকে পরে করে দেব। আগে prayer for transfer, তারপরে voluntary retirement for service. The petitioner underwent an operation. Full stop. Since his prayer for voluntary retirement was turned down, by a letter dated September 22, 2007, the petitioner submitted his resignation on September 24, 2007. Next. Mr. Mohapatra, learned counsel appearing on behalf of the petitioner, relies on a decision, relies on a judgment passed by the Honorable Division Bench of this court. Relies on a judgment dated June 17, 2020 by an Honorable Division Bench of this court. In FMA 4412 of 2016, ব্র্যাকেটের মধ্যে cost titleটা করবেন page 106, bold করবেন cost titleটা, to submit that even after retirement, the employee may be considered to have, even after resignation, the employee may be considered to have voluntarily retired from the service of the bank and may be eligible to opt for pension, full stop. Next. Mr. Mojumdar, learned counsel appearing on behalf of the bank -in-issue submits that the petitioner cannot rely on the decision of the Honorable Division Bench, since the facts of the present case do not tally with the facts in FMA 4412 of 2016, full stop. He submits that the circular applicable to the workmen of the bank is not applicable to the officers of the bank, full stop. Furthermore, the petitioner has also not rendered qualifying period, এটাকে italics এ করুন, of service to be eligible for pensionary benefits, full stop. Next. Since the petitioner did not complete 30 years of service, 30 years of qualifying service, or did not cross the age of 55 years, age of 55 years, he could not apply for voluntary retirement, italics, under the UBI within bracket employees bracket closed pension regulation, 1995. Since he was not a pension optee, full stop. Next. The request for voluntary retirement was therefore turned down by the Deputy General Manager within bracket personnel bracket on September 22, 2007. Full stop. Next. Considering the submissions of the parties, and the materials placed on record, this court is of the view that justice will be subserved by directing the divisional head will file the report. Who will file? Respondent number 3.
On any senior level officer.
The divisional head, comma, Punjab National PNB or
officers
any
related
other
to
authority
regional
delegated
office
by
Kolkata.
him.
Any officer relating to regional office,
Any
Kolkata.
other officer delegated by him to file a report on affidavit explaining why the petitioner's resignation cannot be treated as voluntary retirement for him, retirement, comma, for him to opt for pension under the 2010 scheme. Full stop. Next. Let such report on affidavit be filed by October 19, 2023. Full stop. Exception, comma, if any, by November 28, 2023. Full stop. Next. Let the matter appear for further consideration under the same heading for orders, bolded, on December 6, 2023.
Reply always.
Look at bolded for order.
My lord, I am for the respondent.
And for the petitioner, not sure.
My lord, on the last occasion here, my lord, the petitioner participated in a selection process for promotion from Anganwadi helper to worker. Now her grievance is paragraph 8 at page 6. My lord, paragraph 8, her allegation is that 3 SC candidates were incorporated in the list of general candidates. Paragraph 8, it is pertinent to mention here that as per the notification dated 6 December 2022, out of total 27 seats, 17 seats were allotted for unreserved category and 8 and 2 seats were allotted for the scheduled caste and scheduled tribe respectively. But in the said panel published on 17th May 2023, it is to be found that here that 3 names were inserted in the list of unreserved candidates who are originally belong to scheduled caste category, and despite sufficient vacancy in the scheduled caste category, those 3 names of the candidates inserted in the list of unreserved category, and for that reason the petition was not
They
selected.
got more marks than the
Yes,
candidates in the
yes, yes.
unreserved
I have
category.
the combined merit list, my lord. My lord, now who are those 3 persons, my lord? Very difficult to ascertain. Kindly consider page 22. I find, my lord, 3 tick marks. This is the panel for unreserved, page 22. One Mita Majhi, Saraswati Das, and Kakoli Mondol.
Yes.
And they are not party to this proceeding. In any event, my lord, if I presume that these are the 3 SC candidates, these are admittedly the SC candidates, kindly consider, my lord, serial number 7.
7.
Yes, my lord,
Mita Majhi.
Kakoli. Kakoli Mondol is one of them. My lord, she secured 24.2, my lord, in the list, my lord, combined merit list. Serial number 7.
Yes.
Now then, 9, serial number 9 is the petitioner, Shurotun Begum. She secured 23. Serial number 9,
Yes.
petitioner. Then serial number 13 is another SC candidate, Saraswati Das, 25.8.
Yes.
Then 23, serial number, next page, my lord.
Mita Majhi.
Yes, 27.8. Now, if a reserved candidate, my lord, outperform, my lord, general candidate, my lord,
Have to
she
be
will-
treated as
yes,
general
yes, there is a
category. There are,
settled law, my lord.
Decisions to that effect also.
My lord,
Yes.
kindly fix it at 2, my lord. My lord, I shall place those decisions. Or any day, my lord, subject to your lordship's kind convenience.
Tomorrow.
Tomorrow, very,
Yes. Tomorrow I'll be taking up
very,
a new motion
very, good,
in the first half.
very. good.
Lordship, may I get one copy of the
sure.
combined list so that I can?
Did you look into
একটা
it?
জল দিয়ে দেবেন?
Asha,
আমারটাতে
at the
দাগ
light
দেওয়া
is
আছে।
taken.
আমি আপনাকে দিয়ে দিই।
Written instructions handed over in court today by Mr. Rai Mukherjee. is retained with the records.
এটা তুমি নিয়ে নাও জেরক্স করে ওকে
He submits that the 3 scheduled caste candidates who have been alleged to have been unfairly selected
ফাইনাল
vacancies reserved for UR category candidates
মানে আরেকটা যেটা
have
দিয়েছি
secured more marks than the UR category candidates. Full stop. Next, it is a settled proposition of law that when the SC candidate, when a reserved category candidate secures more marks than the UR category candidates, the reserved category candidates have to be treated as UR category candidates and
9830
will be eligible for
9830.
candidate, will be eligible for engagement stroke appointment
43.
against the vacancies reserved for UR category candidates. Full stop. Next, let the matter come up for further consideration on kalke 27th, on September 27, 2023, bold under the same heading motion bold. এটা দিয়ে দেবেন আজকে সই করে দেবো আগে তাহলে সার্ভার করে দিতে পারবো।
Grateful. আমি পাঠিয়ে দিচ্ছি। Poor my lord, I am for the respondent. My lord, I raised the point of maintainability, my lord. These are steel authorities matters, my lord, recruitment.
My lord, I am for the petitioner, my lord. My lord, only thing, my lord, that can be argued is that, my lord, this is, my lord, with respect to, my lord, recruitment. Once, my lord, the
Yes,
petitioner is
recruitment.
recruited, my lord, once the petitioner is recruited, my lord, it comes under the purview, my lord.
What are you saying? Look into the
Yes, yes, my lord, I've
provision of
gone through
Administrative
that, my lord,
Tribunals Act,
My lord, I've gone through.
process of
My
recruitment.
lord, section,
My lord, with respect to, my lord, Armed Forces Tribunal also, my lord, that principle, my lord, applies.
my lord, section 3Q deals with service matter. My lord, 3Q, my lord. 3Q says, service matters in relation to a person means all matters relating to the conditions of his service in connection with the affairs of the union or of any state or of any local or other authority within the territory of India or under the control of the government of India, or as the case may be of any corporation or society owned or controlled by the government as respects then remuneration, pension, etc. Kindly
14(1)(a). It is
Well,
very clear.
yes.
14(1)(a).
14(1)(a) is very clear. Now, this in 14(1)(a), my lord, it says,
It starts with the word recruitment
yes,
and matters concerning recruitment.
Yes,
14(1)(a).
recruitment,
Why do we
yes.
have to go to 3Q?
yes.
Ashwin?
My lord, kindly gives me a liberty, my lord, to
Yes, yes.
move afresh.
Mr. Rai Mukherjee, Common Learned Counsel, appearing on behalf of the respondents, stroke Steel Authority of India, within bracket same, bracket closed, challenges the maintainability of the writ petition before this court. Full stop. Next. Considering the submissions of the parties,
Yes.
this court is of the view that the appropriate tribunal
Hmm.
is
Now, Vacancy, our
the court at first instance. Following the apex court's decision in L. Chandrakumar, Volota the other one. Full stop. Next, this court does not have the jurisdiction to receive, try and entertain the writ petition. Full stop. Accordingly, WPA 21396 of 2023 bold is dismissed, bold. Full stop. Next, parties will be at liberty to approach the appropriate forum, comma, if so advised, full stop. Next. It is made clear that this court has not gone into the merits of the writ petition. post of server clerk.
Grateful, grateful.
Thank you.
Please, your survive petitioners in this matter. Item number 5.
5 minute, I am for the respondents and lead by the learned aged
Time yesterday.
yesterday, my lord. And my lord, he's out of station, my lord. So it is.
Why did you not tell me? You told me that yesterday he is on his legs. That's why I've kept it today.
Correct.
I clearly remember that you have taken time yesterday. So why did you not say that he will be out of town?
Yes, my lord. I am also raising the maintainability point, my lord,
Why?
regarding the maintainability of the writ petition, my lord. As because, my lord, admittedly the matter is related to the Contract Labor Abolition and Regulation Act, my lord. They are paid for regularization of the railway contract labor. And my lord, according to the recent decision of our High Court, which is based on the judgment of the Honorable Supreme Court, the no writ petition is maintainable. They have to go approach before the labor court or the tribunal, my lord. My lord, kindly.
Lordship, before that, if Lordship may permit me 2 minutes, I
And my
can.
lord,
Let me see. The point of maintenance is being urged. I have to see that.
Please, Lordship, in fact, I just want to draw attention page number 83. It has already been.
kindly come to the paragraph 6, my lord. Paragraph 6, page 6, paragraph 6, my lord. And further, the Honorable Full Bench also took note of the decision of the Steel Authority of India Limited and held that the disputed question of facts cannot be adjudicated in the writ petition, and it is the Industrial Tribunal Labor Court that would be the appropriate authority to determine the issue. In the light of the settled legal position, the relief granted by the learned writ court directing the regularization of the grant of permanent employee to the members of the respondent trade union is wholly without jurisdiction. We make it clear that the respondent trade union should not be left remedialess, as pointed out by the Honorable Supreme Court as well as by the Honorable Full Bench of this court. It is the Industrial Tribunal which would be the appropriate forum before whom the trade union can raise the dispute. For all the above reasons, the appeal is allowed and the order passed by the learned writ court is set aside and the writ petition is dismissed with liberty to the respondent trade union to raise the dispute before the appropriate industrial tribunal. And if it is done, the dispute shall be entertained without reference to the limitation, and the trade union will be entitled to canvass all the factual and legal issues before the tribunal, which shall be considered and decided in accordance with law. Since the matter is lingering from 2006, if the respondent trade union raised the dispute within the period of 2 months from the date of receipt of the server copy of this order, then the concerned industrial tribunal shall expeditiously dispose the matter subject to the parties cooperating in the disposal, preferring within a period of 3 months from the date of which the oral and documentary evidence are marked. And my lord, in this matter, which is I am referring, my lord, it is also related to the regularization of the contract labor who were working before the metro railway. And my lord, my learned friend is relying which decision annexed also in the writ petition, that is related to the parcel porter of the railway. My lord, regarding the railway parcel porter, they have the different scheme, my lord. And my lord, it is admittedly, my lord, they are not the parcel porter of the railway. And my lord, they are purely, my lord, they are the contract labor and they are working in the various field of the railway. Admittedly, my lord. For a moment, my lord, kindly come to the page 94, my lord. Page 94, my lord. Page 94, my lord, the last paragraph. In the view of the above, I am to submit that the recommendation in a nutshell as below on the engagement of contract labor with the contractor mentioned above, who are engaged in the establishment of Southeastern Railway in various category of work, such as cleaning, sweeping, on board housekeeping, bedroll service, LP box portal, clerical and locking and unlocking AC coach, attendant, train lighting, and BG set operator. My lord, they are not the parcel porter, my lord. Parcel porter is a separate specific category of the railway, my lord. And for
He is saying that in terms of the order dated December 2021, their case should also be considered. Their case should also be considered by the Deputy Chief Labour Commissioner. That is what the writ petitioner is submitting. It is not that he is asking the writ court to adjudicate the rights and go after going into the facts. Going into the facts and adjudication of rights, he wants the Deputy Chief Labour Commissioner to solve the issue. That is what he is saying.
and they are, that is the manner the concerned labor commissioner they have already considered. This is the they are, my lord, that start from page 86, my lord. Deputy Chief Labour Commissioner, Central Kolkata, my lord, page 86. They have approved before them.
That's the relevant portion is page 95. All the findings are 95, given by the Deputy Chief.
Is this not a Group 3 matter?
That's Group D.
Group 3
Yes, my lord, that may be, my lord.
is not a Group 3 matter. See, someone sitting there is nodding his head.
Yes, yes, yes.
So this should
My
be,
lord is
because if
asking-
he's challenging this decision of the Labour Commissioner, then this should be Deputy Chief Labour
Yes.
Commissioner, then this should be a Group 3 matter. How has he filed
No,
that?
no, Lordship, I am not challenging the Deputy Labour Commissioner's report. What I am praying before your Lordship right now, that despite finding of the Deputy Chief Labour Commissioner, despite thereafter separate representation we have given, the railway authorities are not concerning. That is my point here. Findings are there.
Can you
Thereafter,
submit again? Can you submit again slowly? I can't hear you.
Lordship.
Yes.
Lordship, in fact, the Deputy Chief Labour Commissioner has inquired the matter, submitted a report,
Yes.
wherein it has been founded that we all are working at least from 2 years to 18 years continuously. Work is a perennial nature, and a benefit of continuous engagement be given to the
Whatever
petitioners.
it is, it should go before the bench taking up Group 3 matters.
No, Lordship, what happened thereafter? May kindly see the page number,
How
Why not-
have you filed it under Group 6?
page 117, Lordship. After the finding of the Deputy Chief Labour Commissioner, may kindly consider our case. Page number, Lordship, 117.
Yes.
20th September 2022.
Yes.
We have submitted a representation, and thereafter reminders also said they are not taking any note whether what they are going to be done. So now my prayer is before your Lordship, may kindly direct them to regularize me, giving priority to the parcel and goods porters. We are equivalent, report is also same, work is perennial.
Tell me something. Were these writ petitioners before the Deputy Chief Labour Commissioner?
Bilkul, please.
Were all these writ petitioners before the Deputy Chief Labour Commissioner?
For scrutiny under the order of your Lordship's earlier order.
Were these writ petitioners before him or not?
Before,
Were all these writ
Before.
petitioners before him?
correct, Lordship. They were before the Deputy Chief Labour Commissioner.
Yes. So now,
As per Lordship,
Now-
may kindly page number 84. I just want to read page 84, only the operative portion of your Lordship's earlier order. Page 84.
I have read this.
Lordship,
Why is this not filed under Group 3?
then your Lordship, I will clarify the issue.
Wait, let me inquire. I am keeping it next week. Let me inquire.
Lordship,
To my mind, it should be filed in Group 3. Please wait.
correct.
Ashun,
Lordship,
in the present writ petition, the petitioners pray for implementation of the report submitted by the Deputy Chief Labor Commissioner dated September 13, 2022, in compliance of an order passed by the Honorable Coordinate Bench in WPA number 13736 of 2021. Order dated December 20, 2021. Passed in WPA number such and such of 2021. Next. The Deputy Chief Labor Commissioner upon inquiry held that the benefit of the continuous engagement from the year on which the contract laborers were engaged may be given to the contract laborers for the ends of justice. Full stop. The petitioners pray for implementation of such recommendation by the Union of India and also the General Manager, Southeastern Railway. Full stop. Next. Let the matter come up for further consideration. Under the same heading motion bolded on October 4, 2023. Bolded. Server copy.
Lordship, one prayer. Item number 21 is also likewise.
I do not
Connected
know who is appearing for Union of India in item number 21. You are appearing in item 21?
Please, Lords.
No, my
I am
lord.
Then how can I?
And my lord, kindly also direct my learned friend to correct the cost title regarding the address of the respondent number 3. My lord, the divisional railway manager, Southeastern Railway, Midnapur, West Bengal. My lord, in which division?
Wait, first let me see
Yes.
whether I have the determination or not. Let me just inquire and find out.
Please, Lords.
My lord, I may pay for the petition, your lordship. Lordship, this is a matter where I have challenged the order passed by the West Bengal Transport Corporation, your lordship, formerly known as CTC, your lordship, that I was compelled to retire on medical ground, your lordship. Your lordship, the gist facts of the case is that, your lordship, this cause of action arose while I was in duty in 1984, your lordship. While I was in duty, I sustained injury. So my leave was granted by I overstayed. Therefore, more than 90 days, your lordship. So by the order, your lordship, I was terminated from service. I preferred a writ petition before this honorable court, and this honorable court was pleased to dismiss my writ application. Then I preferred an appeal, your lordship, before the division bench, and the honorable division bench was pleased to set aside the order of termination, your lordship. And the observation of the division bench is that, your lordship, that the order under appeal is set aside, the order of termination is set aside, the appellant be allowed to join his service forthwith. As soon as he joins the company, would be entitled to put him under suspension and start proceeding departmentally for such unauthorized absence. This was the observation of the Honorable Division Bench, your lordship. Your lordship, what happens, your lordship? When I went to the corporation to join my service, your lordship, they put me under suspension, Your Lordship. So until and unless the suspension order is revoked, I cannot resume my duty, Your Lordship. And after that, they started a departmental proceeding against me, Your Lordship. And after that, many writ applications was moved before this honorable court, and the honorable judges made several observations, Your Lordship. Sometimes the inquiry report was not supplied, so I was not supplied with a standing order, Your Lordship, everything. But lastly, what happens, Your Lordship, my lord, on 21st of April 2021, Your Lordship, the disciplinary proceeding culminated into a final order where I was retired on medical ground. Without examining me medically, Your Lordship, they have passed this order that I am retired on medical ground, Your Lordship. So now, Your Lordship, I preferred a departmental appeal against this final order on 12th of May 2022, Your Lordship. That was pending. They sat tight over this appeal, Your Lordship. Then I preferred a writ petition before this honorable court in 2023. And my lord, on 2nd of March 2023, was pleased to dispose of the writ petition, directing the corporation to dispose of my appeal. And when they disposed of my appeal, Your Lordship, the final order where I was retired on medical ground, that order was set aside. And when they passed this order, the same order was passed against me, that retired on medical ground, Your Lordship. Well, kindly see the order. Your Lordship, this order was passed by the senior engineer, who is much below the rank of my appointing authority, Your Lordship. Your Lordship, the final, this order, 20th of July 2023, P20, Anisha P20, page 99, Your Lordship. Kindly see the last page of this order at page 101. The third last paragraph, Your Lordship, and whereas from the above records, it appears that Sri Bimal Kumar Das did not join his duties as conductor in spite of being allowed to do so after carefully examining all the relevant documents, and as Sri Bimal Kumar Das did not appear for hearing, being given no opportunity, Your Lordship, 2 opportunities. The undersigned hereby imposes a penalty of retired on medical ground in persons of Rule 9C of the revised leave rules of the company. He has already superannuated. The period from 9/8/1994 till his superannuation is to be treated as diastema. Your Lordship, I was retired on medical ground, but I was neither informed that what is the date of my retirement, Your Lordship. But it is an admitted fact, Your Lordship, as per my office record, I used to retire long back, Your Lordship. But by this order, Your Lordship, they have retired on medical ground. So if I am retired on medical ground, that I'm entitled to get the pensionary benefits and other terminal benefits, but they have not disbursed anything, Your Lordship. And so, Your Lordship, I want to resume my duties, but as such, I was under suspension, Your Lordship, until and unless the suspension order is revoked, Your Lordship, I am not.
So naturally, you have not joined your duties. You were in unauthorized leave. Obviously, you have been put on suspension.
Lordship, yes, Your Lordship,
What
but
is
Your
your
Lordship, the
regards with regard to
departmental
that?
proceedings started against me, Your Lordship, and then I
They have to
attended
put
the
you in
departmental
suspension.
proceedings.
So they have to put you in suspension and then conduct the departmental proceedings.
Yes, Your Lordship. Departmental proceeding, but the departmental proceeding results in this, Your Lordship, in 2021.
The period between 1994 till his superannuation will
So
be
I
treated
was
as
never
dias non.
intimated.
So if at all any entitlement is till August 9, 1994.
Lordship.
My lord, if there is any entitlement of the petitioner will be paid accordingly. But my lord, so far as the suspension goes and the disciplinary proceeding goes, my lord, if the rules of the corporation is, if an employee is absent from duty without any intimation, my lord, then that employee is supposed
I
to
am
be
not going into the departmental proceedings at all.
Yes.
You file a report and you show whether he is entitled to any retired benefits up to 1994.
Up to 1994, my lord.
Yes. What his benefits are that he is eligible for, because from 1994 till his superannuation, whenever it is treated as dias non.
Yes.
So up to 1994, what he is eligible for, you file a report.
My lord.
Tell me who is the concerned respondent.
My lord, may I have my lord signing that?
When has he joined service?
Lordship. Your Lordship, he was admitted in, Your Lordship, I'm sorry, Your Lordship, it is not written over there. He joined his service, Your Lordship. It was there that.
So
he
you're
suspended
asking for
him.
retirement benefits you have not written when he has joined service. Ashun. Mhm.
No, managing director.
The petitioner was working as a conductor with Calcutta Tramways Limited within bracket CTC. Bracket closed 1978 bracket er moddhe limited, comma. Now known as the West Bengal Transport Corporation Limited within bracket WBTCL. Full stop. The petitioner was on unauthorized leave. Full stop. Mm. After several rounds of litigation, after several rounds of litigation, comma, the authorities passed an order. The disciplinary authority passed an order on April 21, 2021. Full stop. The petitioner was imposed a penalty of retirement on medical grounds pursuant to rule Roman 10 within bracket C of the revised leave rules within bracket CTC bracket close 1991. Next, from the final order passed by the disciplinary authority, comma, the petitioner preferred a statutory appeal before the appellate authority. Full stop. The said statutory appeal was disposed of by an order dated July 20, 2023. Full stop. The appellate authority also retired the petitioner on medical grounds. Now, the appellate authority also directed the petitioner to retire on medical grounds. Full stop. Next, the petitioner had already superannuated. Full stop. The period between August 9, 1994 till his superannuation was to be treated as dies non, inverted commas, italics. Full stop. Next. Ms. Debasu, learned counsel appearing on behalf of the petitioner submits that since the petitioner has been retired on medical grounds, he is eligible to pensionary benefits and other retirement benefits. Full stop. Next. Ms. Chottaraj, learned counsel appearing on behalf of WBTCL. Ms. Chottaraj, learned counsel appearing on behalf of WBTCL submits that there is no infirmity in the decision-making process. Full stop. Since the petitioner absented himself without intimation, comma, the petitioner was imposed the penalty as thought fit by the disciplinary authority and the appellate authority. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court finds that justice will be subserved by directing. Who is the respondent concerned?
Respondent number 3.
Directing the respondent number 3 stroke the managing director, comma, WBTCL. file a report on affidavit R capital A capital. Report -on affidavit. On the issue of the entitlement of the petitioner to retirement benefits till August 9, 1994. Full stop. Next, let such report on affidavit be filed by, yes, Mr. Apparat,
My lord, 3 weeks. my lord.
by October 19, 2023, full stop. Exception, if any, by November 28, 2023, full stop. Next, let the matter appear under the same heading motion bolded on December 4, 2023, bolded. Motion target bolded, server copy.
Report me on this final error is an enigma, my lord. You lost me on threefold ground. I am submitting this. It's an enigma. As enigma as Mona Lisa smile. First of all, the final error was passed on 27, 20.
Now the question, what you have done, you know
Yes.
what you have done, you were on unauthorized leave. The question is whether you will be granted any pensionary benefits or not.
No,
Let them come with the,
no pensionary benefit. I have been.
I am saying the issue is whether you will be granted or not up to 1994. Let them come up with a report.
Yes, yes.
For the state respondent, next part, my part is next part, regarding payment part.
My lord, I am challenging the appointment of private respondent number 10. Petitioner applied for the post of Asha. Advertisement was published on 20 April 2022. And said advertisement petitioner came to know that respondent number 10 did not come within the required age, that is 30 years. Page 19 to 22, advertisement window. And I have stated in para 2.
Where is the advertisement?
Yes, my lord. Page 19 to 22, my lord. Page 19.
And where is the age
Age
limit?
criteria, my lord. Yes, my lord. Column 3, page 19. As on 1st January 22, should be within the age 30 to 40 years. In case of
Page 19, column 3.
yes, my lord. Column 3.
All right, between 30 to
Yes, ma'am.
40 years.
Yes, my lord.
So now
She
your
did not.
contention is that she was not 30 as on
Yes, ma'am.
January 1.
And surprisingly, she had produced a fake admit card. Page.
And is she an SC candidate?
No, she is general candidate, I think. OBC.
Already.
Yeah. My lord, she had produced a fake certificate. That is, my lord, page 40. Page 40, my lord.
1 second.
No. No, my lord, page 37, lordship, kindly come to me. 15 June 91. Date of birth. This is a fake admit card. And turn to the, my lord, page 40. Subdivisional officer, Jhalda subdivision, forwarded Chandramulika Mahato. That is the petition in reference to your letter dated 20 April 2020. The communication had been made to the District Inspector of Schools, Secondary Education, Purulia. Accordingly, report has been received and the same along with the enclosure at a jail. Turn to the next page. Verification of admit cards in Lolita Mahato, that is the private respondent. As per available records and written statement, teacher in charge of Ichiak High School, that is located at Jhalda, Purulia. Name of Lolita Mahato, date of birth, my lord. Their admit card date of birth in 1991, 15 June, and they have date of birth in 15 June 1992. And the next page regarding verification admit card is subdivisional officer forwarded with the DI. Enclosed, please find here is a copy of admit card Lolita Mahato, village sub-center Khamar under Jhalda. You are requested to arrange verification of this admit card. Complaint has been received by one Chandramulika Mahato. Genuinity of said admit card. And complaint, my lord, is page 43. ভুয়ো অ্যাডমিট কার্ড মাধ্যমিকের মাধ্যমে আশা কর্মী নিয়োগের তদন্ত সাম্প্রতিক অতীতে আশা কর্মী নিয়োগের বিজ্ঞপ্তি
It's all right. That is all right. I don't have to go
yes,
through
my
the
lord.
content.
And verification record and school register admission register page 46, first column, Lolita Mahato, date of birth, my lord, 15 June 1992.
Page 46.
6, admission register. He has recorded, page 41 recorded the date of birth, 15 June 1992, as per school admission register. And school admission register, page 46. Serious allegation.
My lord, after the
And objection, my lord, page 54. My objects.
my lord, after the selection process, my lord, at the time of verification, my lord, the discrepancy was found, and my lord, we wrote a letter dated 27 June 2023 to the President, West Bengal Board of Secondary Education, my lord.
Yes.
Your lordship, kindly consider this letter.
Yes.
This was written by the DI of Purulia. Second paragraph, as per statement of TIC of such and such high school, it is found that there is a contradiction in date of birth between the Madhyamik Pariksha admit card and in school original admission register. According to Madhyamik Pariksha admit card and school
Yes.
original admission register, the date of birth of Lolita Mahato is the private respondent is found 15 June 1991 and 15 June 1992 respectively. At present, the school authority is unable to submit the preserved Xerox copy of admit card of Lolita
This
Mahato. Now-
school authority also could not submit this.
No, they do not have that document. Now,
Yes.
board is the appropriate authority. If board is not a party to this
Yes,
proceeding,
lordship, grant me leave.
yes, my lord, if
As a
my lord, board
respondent.
is made a party to this proceeding, my lord, board can apprise your lord.
A school authority already forwarded, my lord, page 44. Page 44 to the before the DI regarding verification of Madhyamik admit card Lolita Mahato. In reference to your above noted subject, I would like to inform you that the details of Lolita Mahato, daughter of Vibhuti Mahato, given name Lolita Mahato and date of birth 15 June, school register.
I have seen that.
Yes, my lord.
I have
And
seen
admission
that.
register also.
You have to make the board a party.
Yes, ma'am.
The question is whether the board has actually issued this admit card or not, and on what
Yes.
basis of, because usually the date of birth in that register, school registered, is usually forwarded for
Yes,
the
yes.
board to issue the admit card. On what basis, on what documents the board
Yes,
has
yes.
issued? And show me your affidavit of service. Who is representing the private respondent?
কি entry order জানি না। Sir, দেখুন না। এখন কাজ না করতে সেটা সাসপেনশন আসছে।
She has been served.
Yes, sir.
Asha.
Well, I'm praying for an interim order, restraining the respondency and produce a fixed certificate verification. There is. There is.
Affidavit of service filed in court today is written. Stop. Despite service, no one represents the private respondents. Private respondent. Not respondent.
Respondent number 10.
10. Full stop. Next. Leave as paid for by the petitioner to make, now to add the, should the district inspector of schools be added as a party?
My lord,
Yes.
Or the
DI
president?
DI
the
and
West
board,
Bengal
all both.
DI is not a party to this. Yes, DI is also,
DI is
Well,
also
DI
DI
listed.
has to be added.
DI and
And
board.
also the West Bengal Board of
secondary.
To add the district inspector of schools, comma, secondary education, comma, Purulia. And also the West Bengal Board of Secondary Education as party respondents is granted. Full stop. Next. Leave is granted to make necessary amendments to the cost title. Full stop. Next. The petitioner participated in a recruitment process, advertised 3-day, memo dated April 20, 2022 for engagement as an accredited social health activist within bracket Asha bracket closed. Karmi. In what is the subcenter?
Khamar subcenter. I've stated in para 2. Khamar subcenter under Mathari Khamar Gram Panchayat. This is Jhalda one.
In subcenter hyphen Khamar, comma, Gram Panchayat Mathari Khamar,
Yes.
block Jhalda hyphen Roman 1 and Roman 2. Full stop. The Roman 2, comma, district hyphen Purulia. Full stop. Next. After the learned counsel appearing for the petitioner submits that the candidates who participated in the selection process had to be within the age group of 30-40 years as on January 1, 2022. Full stop. Only in case of SC/ST candidates, the lower age limit could be relaxed to 22 years. Full stop. Next. Admittedly, the private respondent number 10 is an OBC candidate. Full stop. Therefore, comma, she could not have been engaged in the post of Asha. Full stop. Next. It is submitted, comma, that the private respondent number 10 relied on a fake admission card issued by the fake admission card evidencing her date of birth as June 15, 1991, comma, issued by the West Bengal Board of Secondary Education. Full stop. Next. The date of birth of the private respondent number 10
And deputy secretary, signature of my lord. Deputy.
June 15, 1992. Full stop. Next. Upon verification by the district inspector of schools, comma, Purulia, it was stated that as per the available records and written statements of the teacher in charge of ICHAG, Ichhag High School, within bracket HS, bracket close, Purulia, the date of birth of the private respondent was June 15, 1992. Full stop. The DI wrote to the subdivisional officer intimating the same. Full stop. Next. The TIC of the school wrote to the DI on May 4, 2023, intimating the date of birth of the petitioner as June 15, 1992, as per the school admission register. Full stop. Next. Mr. Rai Mukherjee, learned counsel appearing on behalf of the state respondents, hands over to the court written instructions, which are retained with the records. Full stop. From the said written instructions dated June 27, 2023, issued by the DI, it appears that there is a contradiction contradiction in the date of birth as per the Madhyamik Pariksha admit card and the school's original admission register, full stop. Therefore, the said fact was brought to the notice of the President, comma, West Bengal Board of Secondary Education, full stop. The added respondent was also requested to provide the date of birth of the private respondent as per the board's record to verify the date stated on the admit card so that a concrete conclusion could be reached about the genuinity of the admit card, full stop. Next. Let the matter appear for further consideration on October 9, 2023, full stop. Next. A proof of service on the added respondents will be filed on the adjourned date of hearing, full stop. Server copy.
I'm praying for an entry model.
Sorry, not now, because it has to be
She had
seen.
produced the certificate
It
verification
has to
report.
be seen. Come back on the 9th. I've kept it
Get
this
it.
side of the vacation.
Grateful, Lord.
Item number 8, my lord, I appear on behalf of WBACTC. Petition. নামটা দিয়ে আমার নামটা
Yes.
ফাইলটা দিয়েছে Yes, my lord, challenging the order, my lord, page 59.
Yes.
But this is a compassionate appointment, my lord. The petitioner's father was, my lord, was working under the PDCL, my lord. And then, my lord, petitioner's father was died, my lord, on 22nd October 2010, my lord. And he applied at the age of, my lord, 48. And he applied in time, within 2 months. Then, my lord, petitioner appeared and the authority passed the order, page which he under challenge, my lord, page 59. May I read, my lord?
1 second. So what is the infirmity in the order?
Yes, my lord, next, my lord, page 64A also, my lord.
Yes.
Subsequently, order, my lord, has been passed.
This is a representation in respect of the order.
My lord, my not consider, my lord. My lord,
Yes, what is
my
the
lord,
infirmity
page,
in the order?
my page,
Why have you filed this writ petition?
well, they not consider my case.
Why? Why will they consider?
My lord, petitioner, my lord, appeared in the examination, my lord, page, my lord,
Yes, I have understood. He appeared and he qualified, but why should he
qualified
consider?
and he successful
Yes,
candidate.
then
And then, my lord, the petitioner could not contact and also, my lord, filed, my lord, with the application computer certificate. My lord, his case not considered.
with the application he filed,
Yes,
or
also-
after 9 years he filed.
No, my lord, not, my lord, I'm coming, my lord. My lord, page 49, you will see, I'm giving answer to the law point, my lord, page 49. My lord, when I applied in time, page 49, you will not see kindly.
You please show me when he has supplied the computer test certificate.
Well, with the first time, my lord, applied my lord for computer certificate from the my lord, Mecheda Youth Computer Training Center. That was
When?
not that was not accepted.
Yes.
Madam,
Then he was supposed to give the required certificate, and when has he given? After
Madam,
the Viva Bosi, when has he
not
given?
for the post of competent enough, not required to
All right.
competitive for
This is
examination. My lord,
Achun,
my lord,
the petitioner has challenged an impugned order dated,
both the order.
has challenged impugned orders dated September 27, 2022 and June 27, 2023. Full stop. The petitioner's father was a permanent employee of West Bengal State Electricity Distribution Company Limited, within bracket WPACDCL bracket closed. Full stop. He died in harness on October 22, 2010. Full stop. The petitioner prayed for compassionate appointment. Full stop. Next.
On
The
27th
petitioner was found eligible in the selection test. Full stop. The petitioner
Petitioner is praying for petitioner is praying for appointment in regard to land loser scheme. My lord. Petitioner's father was a patta holder, my lord, and his land was acquired by the government for development of irrigation at Monga. Compensation has been paid, but my lord, according to the notification issued by the Labor Department, a family member of the land user is entitled to get employment. My lord, kindly come at page 26. My lord, clause 3, person belonging to the families of land user. Candidates hailing from families who might have been uprooted from their places of residence due to acquisition of homestead land by the government, or whose main source of income is substantially affected due to loss of agricultural land as a result of the land in question being acquired by the government for public purpose, shall also be covered in this category. Only one member from an uprooted or affected family shall be eligible for consideration against the vacancy reserved for exempted categories. The beneficiary should be either an awardee of compensation for acquisition or a member of the family of the awardee. Mother petitioner, before lordship, is a unmarried daughter of the original awardee. My lord, your lordship, kindly come to page 31. It has been informed that her name is in the list of the eligible person, and that has been communicated. My lord, page 31, kindly see bottom portion. Pompa Haldar, she is advised to enroll her name in the exempted category cell of the Director of Employment. As per their advice, my lord, she has already enrolled her name at page 36. And thereafter, my lord, they are slipping. My lord, I made a representation before the authority, my lord, at page 49, annexure P15.
Yes.
Lordship, I'm appearing for the Directorate of Employment. As per the notification, it was specifically said that if there is any vacancy, they will be considered eligible. Lordship, Employment Exchange, their name has been forwarded in the employment card, and Employment Exchange has forwarded her name 3 times on 3 occasions in the year of 2015, 2016, and 2019, Your Lordship, for various for 3 different posts. So, Your Lordship, he cannot ask for mandamus against the Directorate of Employment, because Directorate of Employment has performed its function. It has forwarded her name to different authorities.
And then she was not called because
then it depends on the
concerned
concerned department whether they will give her employment or not.
And it is as per vacancy, because it will, your names will be forwarded and it will be as per vacancy.
Well, I don't know what is the serial number.
Lordship, if I may submit the written instruction, Your Lordship.
Yes.
Well, another thing, well, your lordship should appreciate. It is one kind of compassionate appointment, well, very objective, as if the family may override the
No,
financial.
sir, this is not a compassionate appointment. As and
Yes,
when
like,
the vacancies arise, they will be forwarding your names. And it can take several years. If it is compassionate appointment, that will be defeated by this kind of lapse of time. So this is definitely whenever the vacancies arise, what is the illegality committed by them?
well,
And when have you forwarded these names? You have not mentioned the
Lordship, in
years.
the last years, it has been mentioned in the.
Where
before
have
the
you
noti-
mentioned the years?
Only the last 2019, and before that 16 and in 15. If your
15.
Lordship 26 kindly come
and
to the
in the year
26.
2023, I don't know what is the serial number or is going on, my lord. What is the serial number of the petitioner? And what is the serial number now going on?
In 2019, last
What
appointment
you
has
can
been.
do is, at the most, what can be done is, you make them parties, you take a copy of the written instructions, you make these three people parties, and they will come and answer. This is the most that can be done. Because names have been forwarded to
3 different parties.
to 3 different parties. At the most, this can be done. More than that, nothing can be done because they have not violated your legal right. They have, whenever vacancies have arisen as per their list, they have forwarded your names.
Yes, my lord, but they have not specifically spelled out which serial is going.
That they will, that is not an issue, that they will bring on written instructions. Now, if your name has been forwarded and if there is no vacancy or there are other eligible members
my lord,
who are better suited.
Yes, I appreciate the same, my lord.
Authority's name has been written, your Lordship. 3 different.
And
If you
it's
want, the court can grant you leave, you can bring them on record. This is the most I can do. If that will satisfy your client. Otherwise, nothing more can be done. And I can ask them to produce these memos by way of a report.
My lord, your lordship can do that.
Asha. Mr. Pal, learned counsel appearing for on behalf of the petitioner, submits that the petitioner is eligible for employment in the land losers, inverted commas and land losers category, pursuant to a notification dated August 21, 2002, issued by the Labor Department, Government of West Bengal, full stop. The petitioner's right the petitioner's application in the exempted category within bracket EC bracket closed of a land loser italics was accepted by the district magistrate and collector, North 24 Parganas, Barasat, on May 29, 2011. Full stop. No, 2012. 2012. Full stop. Thereafter, the petitioner enrolled herself with the employment exchange. Full stop. The identity card issued by the employment exchange within bracket EC bracket closed cell is dated April 13, 2013. Full stop. He submits that despite such enrollment in 2013, more than a decade has passed and the petitioner has not been employed till date, full stop. The petitioner has also made a representation on
July 2020.
July 13, 2023. But such representation has not been considered by the respondent's number 4, 6, or 7, full stop. Next. Learned counsel appearing on behalf of the respondent authorities. It next. Stroke. The Director of Employment, West Bengal, hands over written instructions in court today, full stop. Such written instructions dated September 20, 2023 is written with the records, full stop. From the written instructions, it appears that the name of the petitioner has been forwarded thrice, full stop. Therefore, steps have been taken by the respondent number 7 in accordance with law, full stop. Next, considering the rival submissions of the parties and the materials placed on record, this court finds that justice will be subserved by directing the respondent number 7, stroke the Director of Employment, or any other authority delegated by him, to file a report on affidavit evidencing the dates on which the petitioner's name was sponsored by the employment exchange, full stop. The memos by which her name was sponsored will also be brought on record, along with the serial number at which the petitioner is presently placed in the bracketed mode, the EC bracket closed category, full stop. Next, let such report on affidavit be filed by November 17, 2023, full stop. Exception, if any, by December 1, 2023, full stop. Next. Let the matter appear under the same heading motion bolded on December 4, 2023, bold server copy.
Other matter to appear on
4th of December.
Okay.
Filing by
I have further response. The wife of the petitioner, my lord, was an employee under the West Bengal Power Development Corporation Limited. And after her retirement, a pension payment order was issued in favor of her wife. And after the death of wife of the petitioner, a fresh pension order was issued in the year 2016. And she was getting pension as per rules, my lord. And thereafter, all of a sudden, in the year 2020, they curtailed their basic and medical benefit from his pension. And thereafter, we filed a representation before the authority concerned. We came before this honorable court, and Honorable Justice Arindam Mukherjee was pleased to pass an order directing, after hearing both the parties, reason order may be passed. And they passed the reason order also thereafter.
So the petitioner's wife superannuated in 2005.
Yes,
And then she passed away in
2015.
all right. And then another PPO was passed on
2000,
February 2016 in favor of the petitioner.
yes, madam.
All right. And then you were getting pension.
First, I am getting the pension around 15,000. And thereafter, they curtailed the pension in the year 2020.
to 13,800.
From February 2016, you were getting 15,000 and odd.
Yes, my lord.
And then in 2020, the amount was reduced.
Yes, my lord. Your petitioner was an employee before that under the
That is all right. So how much are you getting now?
13,800 per month presently.
13,000.
13,800.
All right.
Annex
Then what
P3,
happened?
my lord.
Then what happened?
I am curtailed the dearness allowance and also medical benefit. So which I am the petitioner is entitled, because as per rules, their rules in the year 1992, the petitioner is entitled to get all the benefits. The West
So
Bengal
they
Power
have
Development.
disposed of the representation made by you
Yes,
in terms of the coordinate bench's order.
yes, my lord.
All right.
Kindly come to page number 30, 39.
That order is impugned.
Yes, 26 page number. The representation. What a file.
No, the recent order is
An order, the
impugned.
order kindly come to last page, 36. And bottom of that page, my lord. Well, in the bottom of that page, they've written there, which is an consistent practice. Whereas, my lord, they've written, I have examined the list of pensioners at random, where from I have seen that WPTCL has allowed only the basic pension to such family pensioners who also draw pension from WPTCL or other organization, which is a consistent practice. Just practice, but they did not follow the rules. Their rules did not comply that. Their rules, they did not comply their rules. The rules.
Where are the rules?
Rules are there. I think at present I have no rules, my lord. So in this situation,
what violation are you complaining about? I have to know. All right, let me ask Mr. Dev where the rules are.
Lordship, may I submit one thing?
Yes.
The writ petitioner is a pensioner.
Yes, I have followed that. It is there, written there in your
Yes.
reason.
So it is our consistent.
No, where are your rules? You show me your rules. He's saying that your rules have been violated. You show whether this consistent practice is against your rules or not. This is the only short issue.
May I submit, permitted to submit one thing, Lordship, that rule regarding family pensioner who is enjoying benefit of the family pension from his parent from his pension from his parent organization, he is also enjoying the medical benefit as well as the dearness allowance. This pensioner is enjoying from his parent organization. Now, so far as the family pension is concerned, it is as it
Family pension has to be computed on a certain amount. Now, today this person may have property, otherwise a lot of property. That does not disentitle him from the family pension. Family pension is not like a bounty that you are granting. Pension is his entitlement. Family pension is also his entitlement. Now you have to show me whether there is any rule or not. Otherwise, if your practice is capable of interpretation in two ways, I will have to interpret it in a way that is beneficial to the employee.
Lordship, the thing, I got your Lordship's point that
Yes.
what the difficult, the normal thing is a person will be entitled to double benefit.
Then that has to be specifically specified in the rule that he will not be entitled. Unless you are able to show me that there is a specific rule disentitling him, I will not be able to appreciate your contention that this is a consistent practice.
May I put a question to
If
myself?
there is a specific rule debarring, him from getting this, I'll appreciate your contention. But otherwise, I shall not be able to.
May I put a question to myself? Lordship, my learned friend's client status is a pensioner who is enjoying family pension from our organization. Now, whether he has got any positive right in his favor, being a family pensioner, not a person who is
That
not a,
the
a positive right in the absence of any positive right,
the
Lordship.
pensioner
Enjoying family pension.
yes, no, the lady was a pensioner. The lady has passed away. The lady's family pension will be going to someone, and the spouse is eligible. Male spouse or female spouse is eligible. Whether or not he is a pensioner, or whether or not he is a businessman, whether or not he is in the super rich category does not matter. As per the rules, whether he is entitled to family pension or not.
So far as entitlement of family pension, I am trying to view it in this way: the pensioner is claiming the family pension.
Family pension, as far as the other indirect dependents are concerned, many things can be taken into consideration. But as far as the spouse is concerned, his eligibility has to be accepted.
Absolutely, I am not joining in issue over that. But the point is, the pensioner is claiming a family pension where the benefit
If he
is
lucky
enjoying.
and his wife has been working throughout her life.
Absolutely.
If he is lucky and if he is eligible for that, why will he not claim?
I am not on that.
I cannot understand. You are on what? You have to either show me rules specifically.
Let me take instruction on that. The rules is there.
Asha.
Yep.
Under challenge in the present petition is an order dated February 28, 2022, passed by the executive director within bracket F and A, bracket close full stop. By an order passed by a coordinate bench of this honorable court on February 9, 2022. In WPA 20006 of 2021. The executive director, finance, WBPDCL was directed to consider the representation of the petitioner regarding the eligibility and computation of the family pension, full stop. The brief facts of the case is that the petitioner's wife was a permanent employee of West Bengal Power Development Corporation Limited within bracket WB PDCL bracket closed full stop. She was superannuated from service on October 31, 2005 full stop. Upon superannuation, she received pension from the employer, full stop. She died on May 30, 2015, full stop. After her death, the petitioner received family pension pursuant to the pension payment order within bracket PPO bracket closed, issued on February 2, 2016, full stop. Next, under the said PPO, the petitioner was receiving family pension to the tune of rupees 15,096, full stop. However, from 2020 onwards, such family pension was reduced to rupees 13,800, full stop. Challenging such reduction, the previous petition being WPA 20006 of 2021 was filed, full stop. By the reasoned order, the reasoned stroke impugned order, the executive director held that from the list of pensioners at random, it was found that the family pensioners who also draw pension from WBPDCL or other organizations were only granted basic pension. Full stop. They were not granted any amount on account of medical benefits and dearness allowance. Full stop. Such has been the consistent practice of WBPDCL. Full stop. Next. Mr. De, learned counsel appearing on behalf of WBPDCL is permitted to bring written instructions on record, evidencing the rules which disallow the components of dearness allowance and medical allowance to family pensioners who are themselves pension holders. Full stop. Next. Let such written instructions be produced on the adjourned date of hearing. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on October 12, 2023. Bold. Serve a copy.
Yep.
Just because they have chosen to work doesn't mean that you disentitle them. Just because both have chosen to work doesn't mean that you disentitle them.
That
My lord, I appear for the respondent bank. For the petitioner, your lordship. May I file the affidavit of service? Your lordship, in this matter, we had come up before your lordship once via way of a writ petition, my lord, wherein my claim was with regards to my pension. My retirement benefits were cleared, your lordship. The pension was not given on the ground that I was a provident fund optee and not a pension optee. May I take your lordship's last order in that writ petition, your lordship, which is at page 74. Yes. The operational part, your lordship, it is at page 76. May I read out? However, this court is of the view that justice will be subserved in the event the petitioner is given an opportunity to make a representation before the authority concerned within 4 weeks from date of being considered to be a pension optee. Such representation will be considered by the authority concerned within 4 weeks thereof, giving the petitioner an opportunity of hearing. The documents annexed at page 15 of the writ petition will be taken into consideration while disposing of the presentation of the petitioner. Needless to mention that the petitioner will state in the representation that he would be willing to refund the employer's share of the Provident Fund contribution, as well as will be willing to pay 2.8 times of the revised pay for the month of November 2007 as 30% of the funding gap for the pension scheme. In the event such unequivocal statements are made by the petitioner in the representation, the petitioner's prayer shall be considered and a reasoned order shall be communicated to the petitioner within 2 weeks of passing thereof. Thereafter, your lordship, I make a representation which is at the next page, page 78 on 3rd April 2023. Your lordship, herein in the representation, I say at page 81 at paragraph 7, my lord, that I'm ready to to refund the employer's share of Provident Fund contribution as well as an amount equivalent to 2.8 times. Yes, so that is also there, and I make the representation according to my case, my lord. Thereafter, an order is passed without giving me any opportunity to personally present myself before that order is passed, your lordship. This was passed.
Did I give you a personal hearing?
Your lordship, it is mentioned as an opportunity of hearing. in that order, that an opportunity of hearing will be given to the
All right.
party pursuant to the representation. That was the language, my lord. Thereafter, we were not called personally. We received an order that is passed on 10th July 2023, which is at page 92. Your Lordship, the first 2 pages are reproduction of the order of this Honorable Court, Your Lordship. Then at page 93, Shri Shankarlal Shikdar joined the services of the bank on 3rd August 1984 and retired on 31st January 2018 as single window operation B. And while in employing, the petitioner opted for Provident Fund instead of pension. And accordingly, bank's contribution to Provident Fund as well as employee contribution to Provident Fund as accumulated during his service period was paid to the petitioner after retirement. Therefore, total Provident Fund has been disbursed by the bank to the petitioner. The benefit of pension was introduced in the banking industry as a second retirement benefit in lieu of bank's contribution to Provident Fund in terms of joint note and bipartite settlement dated 29th October 93, signed at the industry level between the managements of various banks and the officers' associations and workmen unions. The said settlement finally culminated in framing statutory regulations under Section 19 of the Banking Companies Act 1970. In terms of the aforementioned, the eligible employees were required to exercise their option for pension within 120 days from the date of notification of the regulation on 29th September 95. The petitioner herein did not opt in lieu of bank's contribution to Provident Fund, and hence he continued to remain a member of contributory.
It's all that is there, yes.
Yes, Your Lordship. Thereafter, my lord, kindly comes page 96, Your Lordship. Shri Shankarlal Shikdar did not opt for pension neither under first option nor under second pension option. The details as lays in the documents. My lord, there is no mention of what documents. The details as laid in the documents show that Shri Shankarlal Shikdar was a Provident Fund optee and not a pension optee.
Yes.
And all that they have arrived at is the last line of that paragraph. There was no deduction by bank as per records. There is, according to me, my lord, there is no basis. Thereafter, Your Lordship, however, on perusal of the same statement, it is shown that bank's contribution of PF amount is also being credited in the said account. Had he been pensioned optee, the bank's contribution would have been credited in the pension corpus and not shown in his individual account. He ought to have pointed out the discrepancy, if any, at that relevant time itself. Raising any issue after his superannuation will be of no avail. This is all that has been arrived at, my lord. And thereafter, on the next page, Your Lordship, as on date, bank has no such scheme, and so his request to deposit his Provident Fund contribution as well as so and so forth cannot be exceeded to. My lord, may I take Your Lordship to?
My lord, before my learned friend submits on merit, my lord, I admit that there has been a grave error by the bank in not giving the opportunity to the petitioner, my lord, of hearing.
And why? And the person has only reiterated the facts which have already been stated in the order.
My
Where
lord,
is the consideration after the order?
my lord, my humble submission before your lordship is that, my lord, of the record, this order, my lord, deserves to be set aside, my lord. May a reconsideration of the representation, my lord, may such order be passed so that, my lord, an opportunity could be given to the petitioner, and my lord, we can.
Just 1 second. There is a division bench judgment where even after the second option, the time period for second option had expired, they were given an opportunity. Just see if you can lay your hands on that. That might
Yes.
strengthen your case.
Yes, Your
I'm
Lordship.
just keeping it, adjourning this. You see, you come back. Then
no,
then it will be easier for you.
And
No,
also, Your
meanwhile-
Lordship, another point is page number 19, my lord. I have annexed a document, their document, where they have accepted that I am a pension optee. That has not been considered at all in the order, which I've also mentioned in the representation at paragraph 3 of my representation. Page
Maybe
19.
it was after the time stipulated. It is possible it is after the time stipulated. And in this kind of cases, madam, it is also a disputed question of fact, because I've seen these kind of documents. There are severe disputed questions of fact because so many employees have given these documents. And you can see that it is not there in the bank's letterhead. So just don't place reliance on that. It will
My
not.
lord, only thing is this is their document, Your Lordship.
No, don't place your reliance on this at the moment,
My lord.
because they will again come back with
My lord.
that this is not in the bank's letterhead. There's that it is, because it is disputed whether this is their
I
document
understand,
or
Your
not.
Lordship. Yes, Your
Because I've
Lordship.
seen these kind of cases. Just see if you can lay your hands on the division bench's order. That will help your case.
Yes, Your Lordship. Kindly keeps the matter next week, then at least, Your Lordship.
Asha. Ms. Lala, learned counsel appearing on behalf of the petitioner, submits that the order passed by this court on March 21, 2023 in WPA 2606 of 2022 has not been complied with by the by the concerned authorities of Punjab National Bank within bracket PNB bracket closed full stop. She submits that the impugned order dated July 10, 2023 passed by the circle head, PNB is not in consonance with this court's order. Full stop. Next, Ms. Porna Rai Choudhury, learned counsel appears on behalf of PNB. Full stop. Next, let the matter appear for further consideration under the same heading motion on October 9, 2023.
My lord, meanwhile, my lord, may the bank call the petitioner, my lord.
The motion are এটাকে bold করে দেবো।
And meanwhile, may the bank call the petitioner, my lord, for the personal hearing, my lord, in compliance to your lordship's earlier order, my lord.
Just 1 minute. Let me just see, because then I have to quash it based on your submission, but then you cannot make that kind of submission. Are you authorized to make it? It will not.
My lord,
if it is
this
by
is-
order of court,
Lordship.
it will not reflect upon you. But today, if I record your submission and quash it, then it will reflect.
My lord
upon
can
you. You are
record
not
my
in the fact-
submission that the opportunity of personal hearing, my lord, was not given. My lord, I have got instructions on that, my lord, and I am
have got
submitting.
instructions
I
on
have
that.
got instructions that the personal hearing, my lord, was not given, and my lord, I am candidly
Let
submitting
me
before
set
this.
set it aside, and then you
Lordship.
ওইটা তলারটা কেটে দিন, let it come for Ms. Rai Choudhury, learned counsel appearing for the bank admits that a personal hearing was not given to the petitioner. Full stop. Next. Accordingly, the order dated, ওই impugned order এর ডেটটা কত ছিল?
Order dated, my lord.
Is set aside and
10th July
Quashed.
2023. Your
full stop.
March 20.
WPA number blank of 2023 is disposed of, bolded, server copy, full stop.
Lordship. I'm grateful to you.
Please advise them to take into consideration the observations of the court
Lordship, I was
while
not there in the
consider-
earlier writ petition.
while passing the reasoned order, because there will be another round of litigation.
Lordship,
now.
I've gone through your lordship's last order, your lordship, I'll advise. the
Because
bank.
they have only noted the facts which were already recorded
Already
in that
recorded.
order.
I'm grateful to you.
Grateful.
I'm for the petition. Making note today,
Why?
Mr. Ochinkumar Mujumdar engage your 550.
Ninth.
For the petition. Lord, I'm appealing for the state matter.
WBSC lordship.
Lordship, my compensation appointment has been rejected. Lordship, in the year 2015, I applied for compensation appointment. Lordship, after filing, at the time of filing, I completed my BTech engineering. Lordship, they consider me as a BTech engineer and rejected my application. But my submission is that, Lordship, after filing of my application, I met with an unfortunate accident, rail accident. So, my lord, I was disabled, 70% disabled boy. Now they considering my application as a BTech, but my lordship, kindly consider page after rejection page, rejection as
May I interrupt?
allow me.
Before my learned friend plays this matter, I think my learned friend has not been instructed properly. Under the self-same cause of action before your lordship, this order has been passed. The petitioner is the same person. I have got the earlier writ. That is 8587/2023, Shayantan Mondal. Mother will kindly produce the affidavit.
of that writ petition, son of late Torun Kanti Mondal, and the minor will kindly carry this with this. This is the earlier writ petition.
Nothing to say.
And the prayers are also similar.
কি করেছিল আগেরটা?
কিন্তু দিয়ে দিলাম। কিছু বলে
কিছু করে না, বলেনি তো, এগুলো বলে না, এগুলো বলে না। সবই কিরকম করে না।
হ্যাঁ 5/5/2023
রিজেক্ট করেছিল?
হুম
রিজেকশন রিজেক্টেড?
that has totally been suppressed. Nothing has been stated in this writ petition.
Now,
But if I have no instruction,
I know, then dismissed with costs assessed at 10,000 rupees and then
let me
district magistrate to take steps under the Bengal Public Demands Recovery Act.
also make it not today. I'll get the instruction and
After the other one, learned counsel appears on behalf of the petitioner. Mr. Mukherjee, learned counsel appears on behalf of West Bengal State Electricity Distribution Company Limited, within bracket WBACTCL, full stop. Submits that
কপিটাও তো চাই।
the present writ petition has been filed
WB number
in post suppression of material facts. Full stop. The petitioner's grievance was agitated in WPA 8587 of 2023. And the same was dismissed by this court, vide order dated May 2, 2023, full stop. Suppressing the said order, the petitioner has again agitated his prayer on the self-same cause of action. Full stop. Next. Mr. Shorkar is permitted to take necessary instructions in the matter. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on October 9, 2023. এগুলো ফেরত
কত তারিখ?
এই অর্ডারটা রাখো, এটা ফেরত দিতে।
কত তারিখ?
অর্ডারটা
My lord, when the matter will be?
9th of October.
My lord. I am appearing for this.
নিউ মোশনই রেখে দিও।
I appreciate.
Lordship, learned is appearing for the Union of India is out of station lawsuit. Kindly bring for not this week.
9th.
Much obliged.
Lordship.
My lord, I appear on behalf of the respondent state.
Yes.
Synopsis of the case.
Please speak on the microphone.
That Vasudev Koron was a constable of North Chobbish Pargana District Police. He was missing on 19 January 2001 up from Minakhan Police Station.
He was?
Minakhan Police Station. He was missing.
Maintainability.
Petition is not
Yes.
maintainable, my lord. The original application before the state administrative tribunal is pending.
And then he has come.
Pending, not pending, ওটা withdraw হয়ে গেছে।
So, but why
Withdraw.
have you come before this court? How can you maintain a writ petition? Is this court the court at first instance?
I have received the instruction from the superintendent of police, Barasat. OA number 812/2019.
This is on merits.
Yes.
I do not have to
Rejected.
get into merits. He has to approach the appropriate tribunal.
Appropriate forum. Yes, my lord.
Asha.
Your lordship, এটা
Ms. Ramajpati, learned counsel appearing on behalf of the state respondents, challenges the maintainability of the writ petition before this court. Full stop. The petitioner was working as a constable under the superintendent of police, not 24 Parganas, government of West Bengal. Full stop. Next, considering the submissions of the parties and materials placed on record, this court is of the view that the appropriate tribunal is the court at first instance. Following the decision reported in L. Chandra Kumar, আপনি অন্যদের কারোর থেকে এটা নিয়ে নেবেন, সাইটেশনটা ওদের কাছে দেওয়া আছে, আর cost টাইটেলটা bold হবে. Next, therefore, this court has no jurisdiction to receive, try and entertain the present writ petition. Full stop. Next, accordingly, WPA 21952 of 2023 bold is dismissed. Bold. Full stop. The petitioner will be at liberty to file appropriate proceedings, on the self-same cause of action. Full stop. It is made clear that this court has not gone into the merits of the writ petition. Full stop. ওগুলো bold করে দেবেন, dismissed WPA number, server copy.
I am grateful, ma'am.
May I please, lordship, I am for the petitioner.
Your lordship,
This
Ms.
is my-
Amrita Pandey is appearing for Union of India, your lordship. She is at her legs, your lordship. I am praying for a short passover.
Not today.
Obliged.
Oblige, your lordship.
17.
I'm appearing for the Public Service Commission.
This is the individual service.
আমার তো পিএসসি এটাতে। হ্যাঁ হ্যাঁ, এখানে তো পিএসসির কাছে, আবার সেটা কি আবার যাবে এতে রেসিডিউরি? They have asked for production of documents.
Lordship, in this matter, they are asking for cancellation of the merit list, Lordship, and for the reassessment of the answer scripts. Lordship, as per the order of the Honorable Court, the Commission has disposed of the RTI appeal, and we have also given them the answer scripts, Lordship. The examination was conducted in the year December 2020, 12 December 2020 and 13 December 2020. And the answer scripts were also given to them. There were 128 RTI applications. So answer scripts have been given from 21st November 22, part-wise part, till 5th June 23. And just before they have not raised any, not a single candidate has raised any question of irregularity or filed any complaint before the Commission. Now, just before the publication of the final merit list, they have making vague allegations, Lordship, and asking for cancellation.
The thing is that, is it before this court or is it a Group 9 matter?
My
No,
lord,
no, before
this
this.
is a matter, my lord, which should be heard by the state administrative tribunal.
No, no.
Because, my lord, they are the PSC recruiters. My lord, this case, my lord, is the case of the supervisors. my lord, the supervisors, my lord, in the.
If they get
ICDS
appointment, will it be a service under the state?
under the state,
Will-
because there is, my lord, the two kinds of, my lord, supervisor, my lord, ICDS projects are run by the government. My lord, one is run by the NGO, my lord,
No, one is the contractual engagement.
that is.
That is separate. Now
Now, in
will
these
they be
cases-
appointed as regular employees?
No.
Yes, they will be getting the pensionary benefit, my lord, in a similar type of matters, my lord, the matter was went up because, my lord, the NGO employee supervisors, they claim pensionary benefit. We are giving the pensionary benefit to the government, my lord, employed supervisors, but not the, my lord, NGO supervisors, and that, my lord, we have, my lord, that there is a, my lord, separate case. And another thing, my lord, the PAC.
So what it has gone up where? Before the division
My
bench?
lord, before the division bench.
Where is it? Where is the order?
My lord, order, my lord, at present, my lord, I have not brought that order, my lord.
The question is that whether I will hear the matter or will it be heard by the residuary bench? This is challenging a recruitment process.
Yes.
Then this court can hear it. It's not just for production,
no,
because the
yes.
production
No,
part
Your
is
Worship.
over.
That has been.
All right, yes. So you will get the order passed by the division bench.
Yes, my lord. That,
When?
my lord, keep it on, my lord, third, my lord, I will bring it.
I'm keeping it on the 9th. You get it by that time, because 3rd I cannot accommodate any more matters. Ashu.
My lord, one thing is, my lord, after getting the answer key, my lord, I have, there is several irregularities. my lord.
Wait. Let me see whether this court can entertain
Yes,
the
yes.
petition. Mr. Whole Common Learned Counsel appearing on behalf of the state respondents challenges the maintainability of the writ petition before this court. Full stop. Next. Let the matter come up for further consideration under the same heading motion bold day on October 9, 2023. Bold. Server call.
If I,
It will appear as new motion.
yes, I am happy, my lord, with Topon Kumar. Topon Kumar,
Well, in the meantime, they will fill up the all posts. That should be, my lord.
First, I have to see your entitlement. You cannot just challenge 3-4 questions and come up and say that an interim order has to be granted. If there is any infirmity, it has to be reassessed. If there is
Well,
any infirmity, then obviously it will be subject to the writ
My lord,
petition.
they struck down my marks, my lord, and overwritten, but reduce the marks in all answers.
That I can send for reassessment. First, you
Yes, yes.
show me that I can entertain the writ petition. Then I can send for reassessment by an independent authority.
Yes,
That
yes,
can be done. And in one of the cases, Ms. Sengupta also cooperated, and some of the supervisors
Yes,
were
Lordship.
given engagement.
But here, Lordship, the complaints or irregularities are very
That is
absurd,
right.
Lordship,
That is
vague,
all right.
Lordship.
One,
You take
Lordship.
your,
only,
Yes,
my lord,
Lordship.
see, one
that
thing,
in
my lord,
one of the cases,
Yes,
I
Lordship.
remember
One
that
only
those
Yes, Lordship,
transport
I have filed the
supervisors were
report.
given an appointment.
Yes,
thing
Lordship.
is, them, one,
That person has
initially.
got the job also,
Yes,
Lordship.
yes.
Hmm.
Let us see. You show
Yes.
your entitlement.
I'm grateful, my lord.
So I appear on behalf of the petitioner, may I file my affidavit of service and the payment of deficit fees. Because there are 15 petitioners, I have paid the rest of the. So, Lordship, this is the second round of litigation. Initially, Lordship was directed the matter to be decided by the authority. They have decided against me, challenging that order, the present writ petition. Lordship, according to my understanding, it cannot be heard without calling for affidavits.
Just show me the
Yes,
impugn
Lordship,
order.
kindly come to the impugn order. It starts from page 57. The petitioner before a Lordship, they are the ex-servicemen. On their early retirement, they were recruited under erstwhile United Bank of India. Now, in terms of the defense rules, if their pay is not protected on re-employment, they are entitled to get dearness allowance on their defense pension.
Yes.
Now, we are saying in terms of our appointment letter, there is a circular I have annexed with my writ petition, circular 200, that is applicable for the purpose of calculation of our pay scale. Now, while rejecting our claim,
Pre-fixation of your pay scale. Where is the previous order passed by this?
Lordship, the previous order passed by your Lordship is at page 51. It starts from page 51 and the relevant portion is at the fourth paragraph at page 52. In the light of the submission made herein above, let the representation dated so and so issued by the advocate on behalf of the petitioner be
The
considered
main bone of contention is that you are not getting dearness allowance. Which
on
the
our
other-
defense pension.
Yes, which the other employees are getting.
Yes, apart from these 15 petitioners, all other redesignated or re-employed ex-servicemen, they all are getting dearness allowance on their family pension, defense pension.
File an affidavit.
My lord, I am for the State Bank of India. I do not know why I have been made a party in this proceeding because the impugned order is of the Punjab National Bank, first of all. Second of all, my lord, similar writ petitions challenging this DA on pension, military pension throughout the India, those petitions were transferred by the Honorable Supreme Court pursuant to the direction of the Honorable Supreme Court for all over the high courts of India, transferred to Punjab and Chandigarh High Court. For my lord, today I have come to know, I may tomorrow I can, my lord, if my lord fixes
Lordship,
tomorrow.
kindly keep the matter if that order has been passed.
My lord.
My lord, only one thing, that the representation, my lord, which has been considered, it has been considered only, my lord, for 3 petitioners. My lord, rest did not appear on the day of hearing, my lord. And this
You will go into the merits later.
My lord.
Anyway, you can,
As in lordship,
if I
yes.
give you directions to file affidavits, then you will bring on record all those
Lordship,
facts.
lordship.
But let me see whether this has been transferred to a
Yes,
different
if
high
that
court,
is the case,
so that the same issue can be decided by
Decided
the,
together.
then there won't be multiplicity of judicial proceedings.
Lordship. I'm grateful to your lordship.
Lordship, I have filed the affidavit, let that be record.
I'm just making it not today. If you want to take back the affidavit, please take.
Let it be written with the records.
Your lordship, in item number 19, learned ASG is appearing for the Union of India, your lordship.
So
Your
again,
lordship,
it has
he
to be adjourned.
your lordship, he is not in.
How
It's
many
very
times?
simple matter. I'm only
How many times had it been adjourned?
first time, your lordship.
First time.
Only
Then
praying
come
for
back on the ninth.
consideration.
Come back on the 9th.
before come. My lord, I am for the petitioner. My lord, kindly see my lord's last order. Passed on 14th September, my lord. The state was supposed to come up with instructions, my lord, because our contention was that since you are EC were not fully filled up all the posts, so automatically
Let me hand you original sign.
What instructions did I ask you to take? Come to page 2, internal page 2 of the order. Where is Mr. Mukherjee?
School number 5 is arguing better.
The question is, with this instructions, have you addressed the issue that was raised by this court? Look at internal page 2.
Paragraph 4, your lordship.
I have seen that. Now you look at internal page 2 of the order. What have I asked you to submit? Look at internal page 2 of the order dated September 14, 2023. Where is the previous order of this court?
Mobile, that's it. September order print name. Lordship, last slide, last paragraph.
Page 2.
Page 2.
First paragraph. Therefore, he submits from there.
Therefore, such vacancies were converted.
Therefore, he submits that there is no reason for not converting the vacancies in UR within bracket EC category to UR category. In such events, in the event such vacancies are converted to UR category, the petitioner would automatically be appointed as an OBC B category candidate.
As per directions of this, would you order your lordship? May I submit this report para to your lordships? Kindly see. As per the employment notification such and such, the total vacancy for OBC B category 2 in the.
So am I asking you about that? I am asking you that if the vacancies in UR EC category are not filled, you can appoint candidates in UR category on that score, in that vacancies. Those vacancies will be translated into UR vacancies. And if you do so, these people, the ones you have appointed in OBC B category, you will get those ranks. Then more vacancies will be there in OBC B category.
Already vacancy filled. How much vacancy? All vacancies are.
Which is impossible. You will either answer the queries by the court, because I have not asked you to tell me that the vacancies in OBC B category have been fulfilled.
Filled up as per instruction.
Yes, that is not the instruction given by the court.
Reserve and reserve category both are filled up.
So I have to see whether you have filled it up in accordance with your employment notification or not.
That can show you.
What?
That's no, as per notification.
Yes, how will I know? You have not said that.
For that, Lordship, may I report this file?
You cannot understand the query that the court has raised. I am asking you whether all the vacancies in UR-EC category were fulfilled. If it was not fulfilled, whether it was transferred into UR category. And if it was transferred into UR category, whether the candidates who are appointed in OBCB category, they would have been appointed in UR category. Because once you cannot fill with candidates in UR category, these candidates will rise up in the list according to their merit panel.
Lordship, raising questions, that questions already filled up your Lordship post.
I have to see whether it is properly filled up or not.
I will report your Lordship only 1 week time. Next further report file regarding that part.
That is the only part that I've asked you to explain. I have not asked you to explain that the candidates in the OBCB category have been filled up. That is already there in the repetition.
Unreserved filled up your Lordship. But can you short direction your Lordship next Monday? That would be fine.
Everything has been recorded in this order. No one thought it necessary to go through the order. Asha.
Well, let this be a last chance, my lord, for them.
And then if they don't bring it up, your repetition will be allowed without their instructions.
No, I'm not saying that, my lord. Because they are
Written instructions handed over in court today are
doing
detailed
this
with the records. Full stop. From the written instructions issued by the DP and RTO, Birbhum, dated September 21, 2023, it appears that both the vacancies reserved for OBC-B within bracket EC category candidates have been filled up and no vacancy remains in the said category. Full stop. It is stated that the contention of the petitioner in respect of the fact that any vacancy in the reserved or unreserved within bracket EC category candidates, if not filled up by the said category of candidates, shall wholly be filled up by non-exempted category candidates belonging to aforesaid category, does not apply in the instant matter, since both the vacancies in OBC-B within bracket EC category have been filled up. Full stop. Next. By the order dated September 14, 2023, this court clearly recorded that when the vacancies in unreserved within bracket EC bracket close category or OBC hyphen B within bracket EC, bracket close category, are not filled up by candidates in exempted categories, the vacancies are to be transferred to the category of candidates without such exemption being granted, full stop. The issue is whether the vacancies in the unreserved within bracket EC category candidates have been all filled up by the said category candidates, full stop. If not, whether such vacancies reserved for UR within EC bracket close category candidates have been filled up by UR candidates, full stop. In the event, the candidates who have filled up the vacancies in OBC hyphen B within bracket EC category obtained more marks than the candidates in UR category, then whether their candidature was considered as UR category candidates, full stop. A complete merit panel containing the marks of all the candidates will be produced on the next date, full stop. Next. From the instructions given by the DP and RDO, it does not appear whether the candidates who filled up the vacancies in OBC hyphen B within bracket EC category could have been considered in the UR category on the basis of the marks obtained by them, full stop. Next, it is a well-settled proposition of law that in the event the reserved category candidates obtain more marks than the UR category candidates, then they will be considered as UR category candidates for filling up of the vacancies, full stop. Next, the issue that falls for consideration is whether the candidates who have been appointed in OBC hyphen B within bracket EC category obtained more marks than the UR category candidates and whether they could have been appointed in UR category, full stop. In the event such candidates could be considered for appointment in UR category, then naturally the vacancies in OBC hyphen B within bracket EC category, EC bracket close category, would fall vacant, full stop. Then the question would arise whether the petitioner can be appointed in OBC within bracket EC, OBC hyphen B within bracket EC, bracket close category, full stop. Next, let such written instructions be brought on record. On the adjourned date of hearing, Full stop. Let the matter come up for further consideration under the same heading motion bolded on October 9, 2023. Bold. Server copy.
My lord, in respect of other two matters, 50, other two matters, next two other. No, my lord, I am praying for time. Kindly keeps it on the same date, my lord.
What? No, no. He wants time. He's the petitioner. No, no.
No.
So if
It
he
is
doesn't
regarding
want
cut-off
to do
marks, my
his matter, what will you do? He's praying for time.
Kindly see, kindly.
Call 55. 55. Aage 55 to
Kindly direct them to my lord, submit a copy of this report.
Let me see what her instructions are.
Last occasion, Lordship, your Lordship has pleased to direct Lordship that that serial number 7, as per of the supplementary affidavit filed by the state respondent, that's the marks and that I have served.
This is a supplementary affidavit on behalf of the respondent number 4.
Yes, that has already been filed by the erstwhile advocate, but the copy was maybe the record. But as your Lordship was desired on the last occasion, that's why I held it.
No, the supplementary affidavit is not on record.
This is the supplementary affidavit filed on 19th May, affirmed on 19th May 2020. That copy I have not.
Ashu.
My lord, may I consider and come back this report file?
You have a copy of the
Today they have server.
Report I have. Copy is already there.
Read the instructions.
This is the instruction.
Supplementary affidavit handed over in court today is retained with the records. Full stop. Ms. Sinha, former learned counsel appearing on behalf of the state respondents, files written instructions in court today, issued by the DP and RTO, Birbhum, dated September 21, 2023. Full stop. Such written instructions are retained with the records. Full stop. Let the matter come up for further consideration under the same heading motion.
On 9th, my lord.
On October 9, 2023. Yes, it is. You are saying that the interview was conducted within 15 out of 15 and not out of 10 as was submitted.
Out of 15.
So there is no issue.
But regarding the cutoff marks, they have not yet disclosed.
Number 7 is the last cutoff marks, what he got, and petitioner is much lower to that. And the report only, Lordship, the supplementary report which I have handed over to the Lordship.
All right, I'll consider on the 9th.
The cutoff marks of the written test is cutoff marks has not disclosed.
That one is the instruction today. And
The last empaneled candidate, they have
Serial number 7, they are saying.
given the marks
Yes.
of the last empaneled candidate, though they are saying that there was no formal declaration of cutoff marks, but the last empaneled candidate is the one in the serial number 7.
Right.
And his the marks that he has obtained in the written test is far more than the petitioner. That is her contention.
That is her contention.
And also, it's not so that by giving a lot of marks, full marks in the interview, that that person was selected. So the contention of the petitioner that by giving full marks in the interview, an unfair selection process
ma'am.
has been
That is my
resorted to.
contention.
That is not correct.
That is their contention.
Yes.
$56 to 9th rakho, dada. Oh, dada. $56 to 9th.
One
Okay,
second.
Dilek,
Let me just read the instructions.
Hey, আমাকে দিলে না কিন্তু instruction. Okay.
All right. You are saying that it is not unfair because the total marks obtained by the petitioner is far less than the last selected candidate in the OBC B category.
Yes, Your Lordship, earlier occasion I have filed the supplementary platform, it appear the last mark, the OBC category got 54, and in the 50 petitioner got on both total marks on the 34
Yes, your supplementary affidavit is on record.
Page 7 of my supplement.
All right, they do not want to do it today.
Yes,
Let
I have no objection.
19th May 2023.
Unless the written instruction may be kept on.
Yes. Written instructions as handed over in court today on behalf of DP and RDO dated September 21, 2023 is written with the records, full stop. It appears from the said written instructions that the difference between the last selected candidate in OBC B category and the petitioner is about 20 marks, full stop. Therefore, it is contended on behalf of the state respondents that the writ petition is filed on frivolous grounds, full stop. There is no infirmity in the selection process, full stop. Next. What is the written instructions written with the record? Let the matter appear for further consideration under the same heading motion bolded on October 9, 2023.
Ignorable instructions.
Lordship, I appear on behalf of the private
Yesterday, my lord was considering that this matter, my lord. My lord, the question which came from my lord was from the point of jurisdiction, my lord, that whether, my lord, this matter is maintainable over here or not.
He worked with the respondent number 5 in Bangalore.
Yes, my lord, pension.
He was a member of Employees Provident Fund Organization, Bangalore.
Lordship, if I may just indicate as to what has happened. Till the year 2007, he was associated with respondent number 5. Now, after that, he was an employer of some other company. Now, in this petition, he has not disclosed as to in which company he was previously associated with. He he has not disclosed that. And
how is it relevant?
Because means in accordance to the statutory regulations, he has to disclose as to where he was working, means previously, where he was the last employer.
He's last employed with you.
Lord, not only that, my lord.
Wait, where has he been last employed?
Ma'am, that is not disclosed in the writ petition.
You do not know?
No, your lord.
You are appearing for respondent number 5.
Respondent number 5.
Has he not worked with you?
Yes, he has worked with me till the year 2007.
2007?
Yes.
All right. Now, for which period is he claiming his dues?
Yes, so accordingly, I have, if I may just hand her a copy of this to your lord. I have carried out all my obligations in pursuance of the statutory provisions.
He has forwarded the same.
And most important fact here, your lordship, the respondent number 5 is in Bangalore. The representations that he has made, it is before the Bangalore authorities. Now he comes and file a writ petition here.
That he will have to answer.
He has filed all the documents before the RPFC Bangalore.
All.
Now, my lord. Lord, whatever documents, my lord, the respondent number 5 has sought for. Lord, I have submitted all those documents.
That is, now they are outside the territorial jurisdiction.
I am coming, my lord, to the territorial jurisdiction part, my lord, I am coming. Lord, whatever, my lord, the documents, my lord, today he handed over, my lord. I find that he has already forwarded all my documents which were sent to him, my lord, to the Provident Fund authorities.
Yes, he has.
Yes.
Provident Fund authorities based in Bangalore.
Yes. Now, my lord, Provident Fund based in my lord. Now, my lord, I will wish to rely upon, my lord, a Supreme Court judgment, my lord, a 3-bench judgment, my lord. That is, my lord, of Shanti Devi versus Union of India.
Yes.
Now, my lord.
Are you receiving your pension within the jurisdiction, Shanti Devi?
Yes, my lord. That is the case, my lord. Over here, my lord, the case was that on the point of maintainability, whether a rich court can entertain a, on the.
Over there, she not getting the pension within the jurisdiction?
Yes, Milord.
Yes.
Milord, এটা একটু দিন না।
What was the reasoning?
My lord, the reasoning was that after retirement, my lord, the husband was working in West Bengal and also in Milord Jharkhand. But he filed a, Milord, the wife of the husband, Milord, filed Milord before Patna High Court. Milord, Patna High Court rejected the prayer saying that I don't have territorial jurisdiction. But the appellate court also affirmed the order, and from there, Milord, it went to the Supreme Court, Milord, and the Supreme Court has observed that due to these technicalities, Milord, these things cannot be, Milord. And of course, Milord, cause of action partly has arisen because the scheme certificate, my lord, that was issued to me, Milord, in Kolkata. My lord, I categorically, my lord, I have taken instruction on this point, Milord. So today, Milord, I cannot make to, I am located at my native place.
The reasoning is at paragraph 29 of the decision.
Yes, Milord, 29, 33 and 35 also. So, Milord, today, Milord, I am staying in Kolkata. Milord, may I have worked in Bangalore, Milord. Now I have to travel for pensional benefits to Bangalore. But irrespective of the fact, Milord, that they will not give my pension or release my pension, I are holding time over the
Even if a small part of cause of action arises within the. Now you show me that a small part of cause of action.
Yes, Milord, my employment, Milord, the scheme under which, Milord, I am entitled to. And Milord, my appointment letter, Milord, all those were issued in Kolkata. Milord, from Bangalore, it was issued to me in Kolkata.
Maybe that is not issuing in Kolkata. They have been issued from Bangalore.
Yes, but Milord, I have received, Milord, and
wherever you receive your appointment letter, that
now,
has
Milord,
jurisdiction.
now, Milord, under this also, Milord.
Let me speak. It is not.
No, I'm extremely sorry. Milord.
If you receive your appointment letter in Kolkata and if you have to work in Bangalore, the part of cause of action arises within the jurisdiction.
Now, Milord, may I say, Milord?
Show me the documents which show that a part of cause of action has arisen within.
If I may, your lordship, means it was issued from Bangalore because I do not have any corporate office here in Calcutta.
That is all right.
My office is there at Bangalore. The registered office is there at Bangalore.
And he is working there.
Page 19.
Page
19. Milord, that is, Milord, my appointment, Milord.
Yes, naturally.
That is what I am harping upon, that this is the basic, Milord. This is the basic document. The first document.
You are saying that because of your appointment letter, you are getting the cause of action here.
The cessation, Milord, the pension scheme, Milord, that was also issued to me in Kolkata.
But he will get pension from the RPFC Bangalore.
Now, lordship, in page number 16, he is making
all of you speak at the same time. You will not allow him to complete his submission.
Milord, page 21, the scheme, Milord, it was also, Milord, today, Milord, if these documents are already given, there is no dispute with regards to the fact that I am not entitled to pension, Milord. So, again, going and filing an application over there, that is the main difficulty, Milord. That from 2021, I am entitled to get my pension.
Yes, 19 does not give you a cause of action. Now show what else?
Milord, 21, Milord, that is, Milord, the document.
The pension scheme at Bangalore,
yes,
Karnataka.
Milord, this was also issued to me in Kolkata.
No, that is also not, doesn't also give you a cause of action,
Milord,
now.
And this was, Milord, perhaps, Milord, after the cessation of my post when I was in Kolkata.
All your communications, all your prayer is before the Regional Provident Fund Commissioner, Bangalore.
Yes, Milord.
Now, what else?
Milord, this
you have to
document
show
at page 21, this document, Milord, it was issued in the year 2009.
Yes.
And my, Milord, post got seized on 2007. So, my lord, this was issued to me in Kolkata in the year 2009. I am relying upon this certificate because this is the basis from which I am entitled to get my pension.
Yes, from
but
where?
At that time, I was not in Bangalore also. I was not working also. And trying to, my lord, because I am entitled, that's why, my lord. Otherwise, my lord, If, my lord, on this ground, they are withholding my pension, my lord, that is something, my lord, I am.
No, you have to go before the court which has the jurisdiction. You cannot go to Jammu and Kashmir because you go for a holiday over there and file.
No, that is, my lord, Shanti Devi judgment says that if you are staying on the native place also, so you.
That is the judgment, or
No,
the
not-
judgment is, the reasoning is that paragraph 29.
So
where
that
it-
is for lack of jurisdiction.
So this is also for lack of jurisdiction.
That was, well, not, that was set aside, my lord, the single spence decision.
Yes, what is the decision? Paragraph 29, what is the reasoning of the Supreme Court?
From the facts of the present case, we are of the considered opinion that part of cause of action has arisen within the territorial jurisdiction of Patna High Court.
Now
That-
read.
Yes, my lord. The deceased petitioner was continuously receiving pension for the last 8 years. But pausing here for a moment, my lord, if that be the case, I have received, my lord, my fund authorities also over here, other benefits. Other benefits.
What other benefits? What are you, they have not released your pension. What other benefits have you released?
My lord, other retirement benefits, my lord, I have got, my lord. My lord, that is what I instruction have, my lord.
What instructions? What have the Provident Fund authorities released to you?
And in the savings account, my lord. My lord, then, my lord, I have to, my lord, go before the Bangalore High Court, my lord. I was trying, my
You
lord.
are placing reliance on Shanti Devi. Shanti Devi's paragraph 29 is the basis of the reasoning.
But then I have to, my lord, go, but even if, my lord, on humanitarian ground, my lord,
Wait,
if they
and
consider,
yes,
my lord,
what do you want to say now?
Your lordship, this is means, what to say? Means was talking about this receiving the scheme certificate.
You are saying.
I'm on the
you-
jurisdictional point.
You are saying that you have done your duty.
Yes, I have performed my
So
obligations.
nothing else.
No, nothing
Yes.
from my side.
As per the petitioner, they have submitted the documents before the Bangalore office in August, ma'am.
Asha. The petitioner's grievance is that the Regional Provident Fund Commissioner, Bangalore, has not considered the petitioner's representation for release of pension under the Employees Provident Fund Scheme, 1995. Representation dated for April 17, 2023. 1995, full stop. Furthermore, a demand for justice issued by his advocate. Demand for justice dated May 18, 2023, issued by his advocate. May 18, 2023. Has also not been considered by the RPFC, Bangalore. Full stop. Next. Mrs. Banerjji, learned counsel, appearing on behalf of the PF authorities, challenges the maintainability of the writ petition by submitting that this court has no territorial jurisdiction to entertain the same. Full stop. Next. You are Mr. Chakraborty?
Yes.
Mr. Chakraborty, learned counsel, appearing on behalf of respondent number 5, employer, submits that the employer has taken necessary steps by submitting the PF form -10D, original scheme certificate and non-employment certificate and other required documents before the Assistant PF Commissioner, comma, Bangalore, on August 11, comma, 2023. Full stop. Therefore, comma, the employer is not at fault for delay in grant of pension to the petitioner. Full stop. Next. Mr. Shah, learned counsel appearing on behalf of the petitioner submits that this court has the territorial jurisdiction to entertain the present writ petition, relying on a judgment passed in Civil Appeal number 3630 of 2020. Bracketed মধ্যে cause title টা bold, bracket closed, full stop. Next. He submits that since the petitioner is a retired employee, he should not be retired employee, comma, he should not be directed to file proceedings at Bangalore. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that the decision of Shanti Devi, bold within bracket Supra, does not aid the writ petitioner. Full stop. In the aforesaid case, the Honorable Apex Court held that the Patna High Court had territorial jurisdiction to entertain the writ petition since the deceased petitioner was continuously receiving pension for the last 8 years in the savings bank account maintained with the State Bank of India, comma, Darbhanga, full stop. The stoppage of pension affected the deceased petitioner at his native place, full stop. The petitioner was therefore deprived of the benefit of pension which he was receiving from his employer at the native place, full stop. The stoppage of pension gave rise to the cause of action, comma, which arose at a place where the petitioner was continuously receiving pension, full stop. Therefore, the Supreme Court held that the view of the learned single judge as well as the division bench in holding that the writ petition was not maintainable on the ground of lack of territorial jurisdiction was completely erroneous and caused immense hardship to the petitioner, full stop. Next. It was categorically held that even if a small part of cause of action arose within the territorial jurisdiction of the High Court, the writ petition may be entertained even if the same may not be a determinative factor compelling the High Court to decide the matter on merit, full stop. Next. In the present writ petition, the pension has not yet been received by the petitioner. Full stop. All the correspondence was with the RPFC, Bangalore, full stop. The petitioner also worked in Bangalore, full stop. Therefore, the present writ petition cannot be equated with the case of a retired employee who was receiving pension within the territorial jurisdiction of this court, full stop. Next. Accordingly, WPA 16438 of 2023, bolded, is dismissed, bolded, full stop. The parties will be at liberty. The petitioner will be at liberty to file proceedings before the appropriate forum, if so advised, full stop. It is made clear that this court has not gone into the merits of the writ petition, full stop. ওইগুলো bolded করে দেবেন, WPA number such and such, dismissed, server call. You tried your luck.
I tried my luck.
Knowing well, fully well. But how does Shanti Devi aid you?
No, Millard, that is Millard, in that entire body of the judgment, Millard, the cause of action, the nativeness, Millard, that has been that unnecessarily, Millard, traveling,
No,
Millard.
the entire reasoning is at paragraph 29.
And cause of action, Millard, and read court's power, Millard, everything. Millard,
Everything
was
is there,
discussed.
but Article 226 clearly says where the seat of the
Millard,
where
clause 2.
clause 2, Article
Clause-
26(2)
clause 2.
clearly says that where you should file,
Yes.
where the territorial jurisdiction will be.
Yes.
So,
So that has also.
so how are you
Millard,
getting it over here?
Yes, Millard, I tried my luck only on that point that all the documents. Millard,
Exercising jurisdiction in relation to the territories within which such cause of action wholly or in part arises.
Yes. So I was in part with that the
How
documents.
are you getting the part of
Yes, Millard, I
jurisdiction?
tried my luck because this 62-year-old now, Millard, without money.
I
and filing,
understand the difficulty, but then how are you coming under 226(2)?
Millard, that is Millard, that's why Millard, I tried my luck.
And
Millard,
Shanti Devi's reasoning is not aiding you. That's why I told you that the reasoning is that person was receiving pension within the
No, Millard,
jurisdiction.
but even if Millard, that be the case, Millard, but the wife filed the.
Yes, yes, but
But
the cause of
wife has
action,
no cause of action.
the cause of action is because the pension stopped.
Yes, Millard, but wife, yes, Millard, pension of the petitioner got.
It
the
was stopped,
husband got-
which he was receiving within the territorial jurisdiction.
That's why.
That's why the court held that it is a minuscule part. Maybe on merits, the wife might not win, but it is a minuscule part of the cause of action that was within the territorial jurisdiction.
Millard, may I?
That is Shanti
May I
Devi.
only indulge, ask for one indulgence, Millard, only one line that if the PF authorities, Millard, may expedite, Millard, one line to that. How
I
without,
don't have the jurisdiction, you tell us, Mrs. Banerjee. Mrs.
And
Banerjee, do
yes,
the needful. Why are you not looking into the matter?
Madam, they have
That
submitted
one-
documents in August.
yes, Millard, one line that
In
without,
August, they have submitted by August end, they have filed.
no,
No,
Millard,
they have-
after filing of
the
the
writ
writ
petition has
petition,
come to
Millard, then Millard, the letters coming that you deposit all these documents.
All right, anyway, I'm
Millard,
sure
that's-
if you file appropriate proceedings.
That's
the
why,
case-
Millard, only 1 mile that if maybe.
How is it possible?
That is.
I am not entertaining the writ petition. How is it possible?
That's.
I am not in favor of dismissing writ petitions on the ground of territorial jurisdiction myself, but then I have to consider Article 226 too. How will I pass
This
an
is,
order?
yes, this is a Millard, absolutely Millard out of Millard jurisdiction, but I tried my luck. That is.
Grateful, Your Lordship.
Your Lordship, in this matter, I'm appearing
Yes.
for the petitioner. On the
Yes.
last occasion, Your Lordship was of the view that we have to show that on which document or which page we are relying upon in the service book. My Lord, I have taken instructions. I'm carrying the original service book, Your Lordship. There are two sets of service book. One is with the employer and the other is with the employee. Now, I have the employee set. Along with that, what I have been instructed is that it is also an admitted fact that the employer, that is the respondent authorities, had lost their original service book. So at that point of time, when my aunt had to appoint me as the nominee, an amendment of the service book was done. And they had also signed and stamped that. So where my nomination is there, that is a part of the service book. It is written on the top part of the service book amendment. And there, my
Just
nomination.
show the document. I
Yes.
will have to.
It is also part of the petition. I'm also carrying the original, my lord.
Just show the document.
May I hand over a photocopy or the original?
Just show me the original, then I can ask her to see the original.
Yes.
And did you produce this during the personal hearing?
Yes, Your Lordship. This was even.
Just look into it, madam.
Your Lordship, it was
Says
observed.
amendment of the service book.
Lordship.
And there is a stamp of the BMOH.
Your Lordship, it was observed that they have asked the question to the petitioner, my lord, during the hearing, whether this is a part of the original service book or not. Since it's not a part of the original service book.
Did you show this?
Yes, this document I have been instructed. This is also part of the
Where does
petition.
it find recorded in the impugned order?
Your Lordship, I
No,
shall
no,
state.
he has not taken part in the personal hearing. He has refused to be in the personal hearing on the ground that his lawyer was not been allowed to. He has not produced anything, he has not.
Your
cooperated
Lordship,
with
as I had
the-
mentioned on the last occasion, there was an apprehension, my lord, on the basis of which we did not, because they were not going to give us a receipt of the original service book. They also don't have the copy of, they don't have the original service book.
Did you not produce this document?
This was perhaps, my lord, produced on the last occasion. My lord, kindly takes page 181.
You have seen that.
This is
And look at
this is the amendment page, but
Yes.
the main service book that.
The main service book you also do not have, madam.
Yes.
You look at the stamp and the seal at the end.
BMOH seal.
So now the issue is whether or not this person is entitled or not.
Your Lordship, at page.
And have you not produced this page? That is the relevant
Your
issue.
Lordship, kindly takes up page 181, since I did not participate on the point of advocate, but it has been stated that in the earlier point of time when we had appeared, my lord, earlier petitioner, this is point E, at page
I'm looking
181.
at point E.
Earlier petitioner confessed that the document specially amended page 3 of duplicate service book is not the part of original service book, and he also claimed that this paper is a proof of his nominee document. But in absence of any kind of adoption certificate, this document cannot be accepted as a legally valid document for nomination. The petitioner did not claim to have original service book with him, and he also did not produce any order from the department directing the duplicate service
What you
book.
do is, madam, I am directing another personal hearing. I'm keeping the matter pending.
No.
You will look into this document and you will instruct the authorities to consider whether or not this is a genuine document, looking at the stamp and seal at the bottom of the page. If it is a genuine document, you will consider the representation of the petitioner based on this document. First, you ask them to see whether this is a genuine document or not. And then on that basis, you will consider the.
Lordship, then kindly direct the petitioner to produce at the time of personal hearing before the authority.
Yes, Asha.
Because this original I am not keeping with me.
866 like a photocopy.
Original time of hearing.
The petitioner has challenged the impugned order dated April 10, 2023. Passed by the Block Medical Officer of Health within bracket BMOH, bracket closed. Comma, Shohid Matungini, comma, Purbo Medinipur. Full stop. By the said order, The petitioner was given a personal hearing, but the petitioner denied to appear in person. Full stop. By the said order, it was held. Such prayer of the petitioner was not allowed. Full stop. Furthermore, it was held that the petitioner did not have the duplicate copy of the original service book and claimed his nomination based on amended page 3 of the duplicate service book. Full stop. Full stop. The respondent stroke employer also lost the original service book in their records. Full stop. Next. By an order dated August 21, 2023, this court held that there was no requirement of the petitioner to be represented in represented before the BMOH by a legal representative. Full stop. Next. Considering the submissions of the parties, this court directs the BMOH to give a personal hearing to the petitioner within 6 weeks from date. Full stop. The petitioner will be allowed to produce amended page 3 of the service book. Full stop. In the event the respondent authorities verify the same as a genuine document, the document comma, then the petitioner's representation for grant of the death benefits of his aunt shall be considered in accordance with law. Full stop. A reasoned order shall be passed by BMOH, comma, accordingly. Full stop. The said reasoned order will be produced before this court by way of written instructions, comma, on the adjourned date of hearing. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 4, 2023. Bolded.
Grateful.
Server copy.
Grateful, Your Lordship.
I am for the petitioner.
For the respondent number 2. Respondent number 12. Answering respondent or private respondent?
First state. Lordship, on the last occasion, Lordship is directed to file the report on affidavit, Lordship.
Yes.
The affidavit is not yet ready, Lordship. Though the report and clarification I have, but not in the form of affidavit, Lordship.
And may I submit one?
Where is Mr. Rai Mukherjee? He has not come because the report is not there.
Lordship, the clarification is there and I can.
May I submit one? Lordship, page 31, the basis of the case. And kindly see page 31. That their allegation is page 31. Lordship, serial number 10. I am posted at case book. They are claiming that unreserved, that is
reserved for the general caste category. But my respectful submission is that there in Asha selection process, there is no reservation policy. Here unreserved means everybody has right to apply. Lordship,
Yes.
ma'am, Lordship, allow me. Yes, Lordship, I can, I have the notification of the government. Everybody can apply. General caste, everybody can apply. Or if I am the SC, I will get the only age benefit. That benefit was given to me. Nothing more, nothing less. Lordship, in a same, Lordship, may I submit one notification not in related to South 24 Pargana? This clarification was given by the program officer, State of West Bengal. Kindly see. I'm giving.
देखिए एक कॉपी दो भाई
I'm giving. Lordship, kindly see. Yes. And subsequent notification dated 8 February 2022. Preference to SC/ST, that does not mean that they reserve for SC/ST. That is also clarified. Second paragraph. However, it may be.
You take instructions, madam, on these two notifications.
I give him the notification, Lordship.
The Lordship, and if your Lordship kindly come to the judgment, Lordship, that Hirok Kumar Dilip Bhai Makwana versus Gujarat Public Service.
Page content.
page 51
Lordship, as per my brief note, Lordship, the first point regarding the total marks. Lordship, got the brief note, Lordship?
Yes.
Lordship, the brief note, Lordship, number one, first point is the total marks obtained in the Madhyamik examination by the read petitioner is more than the marks obtained by the private respondent, namely Shutapa Basikarna. First point. The second point, that is regarding the unreserved category. The vacancy of the
petitioner obtained more marks.
Madhyamik petitioner obtained more marks.
Yes.
But the thing is that regarding SC, being an SC, she got the age relaxation. This is the question. The vacancy again, the subcenter in
The question is whether you can reserve the post for a particular category of candidates.
Yes.
Now, if you can reserve the post, then obviously you cannot consider the private respondent number 10's engagement. But if you can reserve it, then obviously the petitioner is a candidate in the UR category.
Lordship, kindly come to the Lordship. This point number 2.
Yes.
Brief note, point number 2. There is no reservation policy regarding selection of Asha since Asha that incentivize volunteers. Preferences incentivize volunteers. Preferences is given to SC/ST candidate in service areas which are predominantly populated by such category. A communication in this regard by memo number such and such, dated such, was also shared with the district. And in the connection of Nirav Kumar Dilip Bhai Makwana. This judgment is in the page number 51 of the writ
Yes.
petition, Lordship. Lordship, kindly come to Lordship, kindly come to page number 53, Lordship. Paragraph number 50.
Page number?
53 of the writ petition.
Yes.
Paragraph number 15.
Yes.
Lordship. The state government, in exercise of its power conferred under Article 309 of the Constitution of India, made rules of 1967 by notification dated 10/10/67 as per sub-rule of Rule 8. The appointing authority has been given powers to relax age limits in favor of the candidate belonging to SC, ST and ACBC and in favor of women candidates to the extent indicated therein. The Ministry of Personal Public Grievances and Pensions filed Office Memorandum dated 22/5/1989 formulated a policy in tune of Article 16(4) of the Constitution of India, which enables the state government to provide for reservation for the category of persons belonging to backward classes. Thereafter, the Ministry of Personal Public Grievances and Pensions filed Office Memorandum such and such. Lordship, again in the Lordship in paragraph number 8, Lordship. 8 in the same page number 54. Relax. I am just reading the portion, Lordship. Relaxed standard have been applied in selection of candidates belonging to scheduled caste, scheduled tribes, and socially and educationally backward classes in terms of the age limit, experience, qualification, permitted number of chances, and written examination, extended zone of consideration larger than what is provided for general category, etc. Then the scheduled caste, scheduled tribes, and specially educationally backward classes candidates selected under such adjustment shall be counted against the reserved post. Such candidate would be deemed to be unavailable for consideration against the unreserved post. Lordship, kindly come to the last page, Lordship, page number 57 of the judgment, Lordship. Lordship, paragraph number 36, Lordship. There is also no merit in the submission of the learned counsel for the appellant that relaxation in age at the initial qualifying stage would not fall foul of the circulars dated 29/1/2000 and 23/7/2004. The distinction sought to be drawn between the preliminary and final examination is the totally different.
Is that why now? How are you? What are you trying to say?
I'm trying to say, Lordship, that Lordship, kindly come to this. It is evident from the advertisement that a person who avails of an age relaxation at the initial stage will necessarily avail the same relaxation at the final stage.
Yes.
We are of the view of the age relaxation granted to the candidate belonging to SC, ST and ACBC category in the instant case is an incident of reservation under Article 16(4) of the Constitution of India. There is no merit in this appeal. It is accordingly dismissed. And similarly, here also, as per the 16(4) considered, and Lordship, the brief note which I have handed over before your Lordship, Lordship, brief note, that is the Government of West Bengal Circular, Lordship, Health and Family Welfare Department. They have also cited this one, Lordship. There is no reservation policy regarding selection of Asha. Since Asha are incentivized volunteer, preferences given to SC/ST candidates in service area which are predominantly populated by such categories.
So ask Mr. Arjun Rai Mukherjee to appear, because whether or not this is violative of the act or not, that he has to come and submit.
Lordship. But according to this, Lordship, in case of Nirav Kumar Dilip Bhai Makwana versus Gujarat Public Service Commission may be referred to, whereby the Honorable Supreme Court had clarified that state government has a discretion to formulate a policy for concession, exemption, preference or relaxation, either conditionally or unconditionally in favor of the backward classes citizens. So as per this only, the selection has been made. So this is the clarification what I like to submit before your Lordship.
No, my lord, may I submit one thing, my lord, subject to your lordship kind permission. No, my lord, a person intending to participate in a selection process for any of the post must be as per the advertisement. The advertisement speaks page 39. Your lordship, if your lordship kindly take up. I have the rules also. This advertisement. My lord, it is 27th of June 2012. Now, as per this advertisement, my lord, this post was declared unreserved. Now, in an unreserved category, I am not, it is not my case that reserved category candidate cannot participate. If he participate in an unreserved category post, then the benefit available to the reserved category, he or she will not get that benefit. He will compete as a general category. Now here the age of private respondent number, my lord, the 12 is below 22.
After this, now judgment has been delivered by our division bench. Also, in this context, you can consider Justice Basak's judgment, which has been recently delivered on this issue. So you have to take into consideration that also, because this judgment of Supreme Court has been, I think, distinguished, or it proceeds on the basis that this judgment of the Supreme Court is based on the notifications. So you have to look into that judgment also. Now, the thing is whether or not these notifications are prior to the date of the advertisement. Now, whether or not the authorities took into consideration these notifications while issuing the advertisement, they have to clarify. If not, then probably the whole advertisement has to go, if it is not done in terms of their own policies. If there is a mistake in this advertisement, then the whole thing has to go.
Whole thing. Well, let him what handed over to your lordship, I do not know. No, I am not telling about it. What she is, my lord, handing over the written notes or something like that. Let it be, my lord, handed over to
one-page instruction that
let it, my lord, handed over
Asha,
to
for engagement of Asha candidates, the posts cannot be reserved.
Yes.
That they let them explain on the report how they are coming to that observation, how they are making that observation, that they will explain on the report on affidavit.
and my lord, a copy to be served upon me. Otherwise, my lord, I cannot.
Directed, they have not done it, Asha. Mr. Sarkar, Learned Counsel, appearing on behalf of the private respondent, hands over a memorandum dated October 8, 2021, issued by the Program Officer, National Health Mission, and Deputy Secretary, Health and Family Welfare Department, Government of West Bengal, to contend that no sanctioned position for selection of Asha Kurmis can be reserved for any specific category. Full stop. The said memorandum was clarified by a memorandum dated February 8, 2023, issued by the same authority. Full stop. In the said memorandum, it has been clarified that for selection of Asha Kurmis, a candidate may mention her caste for the purpose of preference, inverted commas and mode, to be given to her. Full stop. However, such mentioning of the caste for preference, inverted commas, italics, should not be construed as reservation for a particular caste, since Asha is conceptually and inverted commas, italics, incentivized voluntary service, inverted commas closed, full stop. Next. Sinha, learned counsel appearing for the state respondents, hands over the written instructions by the subdivisional officer, Medinipur Shodor, in court today, full stop. From the said written instructions, it appears that there is no reservation policy regarding selection of Asha Kurmis, as they are, inverted commas, italics, incentivized volunteers, inverted commas closed, full stop. Preference may be given to SC/ST candidates in service areas, italics, which are predominantly populated by such categories, full stop. Reference is made to a memo dated November 23, 2022, full stop. Next. A reference is made to the decision passed in Nirav Kumar Bolde, whereby the Honorable Supreme Court has clarified that a state government has a discretion to formulate policies for concession, exemption, preference, or relaxation to be given to the backward classes apostrophe. No, backward classes, either conditionally or unconditionally. Full stop. Therefore, the age relaxation given to the private respondent number 10 was in accordance with the Asha guidelines, full stop. Therefore, since the post was not reserved, that the post could not have been reserved for any category of candidates, there was no infirmity. Candidates for a comma. There was no infirmity in the decision-making process of engaging the private respondent. Full stop. Next. Mr. Acharya, learned counsel appearing on behalf of the petitioner, submits that the respondent authorities could not go beyond the advertisement published by them for engagement of Asha Kurmis with a recruitment notification dated March 21, 2022. Full stop. From the annexure to the said advertisement, it becomes amply clear that the vacancy that arose for block-Keshpur, Gram Panchayat Shorisha Khola, subcenter Digha, was in respect of UR category candidate. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that a report on affidavit R capital A capital is required to be affirmed by the subdivisional officer, bringing on record the notifications based on which it has been submitted that the selection to the post of Asha cannot be reserved for a particular category of candidate. Full stop. Furthermore, it has to be explained why, despite such notification dated November 23, 2022, the selection procedure was continued to be held by the respondent authorities. Full stop. Furthermore, it has to be brought on record how a subsequent notification dated November 23, 2022 can apply in respect of a recruitment notification dated March 21, 2022, within bracket that was issued prior to the said notification, passed in November, bracket closed, full stop. Next. By an order dated August 16, 2023, this court directed this directed the state respondents to file a report on affidavit. Full stop. Since no report on affidavit has been filed till date, comma, time to file the same is extended till October 19, 2023. Full stop. The said report will be filed by the subdivisional officer, comma, Midnapur Shodor, stroke
Lordship-
respondent number
Lordship,
6,
kindly by the respondent number 3 or any other person
or
delegated.
any other person
Lordship, additional mission director, Lordship.
authorized by him. No, let the SDO file because the advertisement has been issued by the SDO, I think,
Or any other person.
or any other person delegated by him to bolechen na. Full stop. Who has issued the advertisement? The Shoddo Shochip? He is the SDO, right?
Lordship,
Look
actually
at page
the-
30.
That is the mission director, NHM. As per the guidelines of NHM.
Tell me who has issued this advertisement?
Lordship, it is same person, it's SDO. And Lordship, kindly see Mohakuma Sasok Mandripur. And
Yes, so this is the SDO.
the same person,
Yes.
SDO.
But the guideline that is by the
Holding the same,
NHM.
holding two posts.
That is by the mission director.
SDO or any other person delegated by him, or the respondent number 3 stroke additional mission director within bracket NHM, bracket closed, full stop. Exception, if any, comma, by October 19, 2023. Full stop. Exception, comma, if any, by November 30, 2023. Full stop. Next, let the matter appear for further consideration under the same heading motion bold on December 4, 2023.
My lord, my second limb of argument is this. Now, my lord, as per the decision of this honorable court, if a person is more qualified than that other, my lord, I shall place, my lord, recently I did one of the matter before your lordship, and your lordship hold that the person who has, my lord, obtained more marks than that of the person selected, therefore that credence has to be given to the person who is, my lord, obtained the more marks. My lord, I shall, my lord, place that
Let me
judgment.
point it out, Lordship. On instruction I'm submitting, Lordship, the petitioner got 354 marks out of 800, whereas the private respondent got 331 marks out of 700. Petitioner got 44%, private respondent got 47.29%. So, yes, this is the instruction. This has been also forwarded. That regarding
bring
the
it on
marks-
record.
Yes, that's some point.
You bring it on record in the report on affidavit.
Lordship, affidavit in exception, yes. Lordship, one copy to me. If any against me, I can.
All right, let them first file. If it is against you, we will give you a copy.
Deeply obliged.
My lord, I'm for the petitioner. This matter in relation to recruitment of constable. Your lordship, by virtue of an order of 16th August, had directed to remeasure my height and to submit a report.
All right, the report is here. Let me see. Fit. 157.5. Not 156.5, 157.5. 7. Every time she remeasures 5.5 centimeter goes up. You have held it to be 156.5. The government hospital has held it to be 157, and now Eastern Command is holding it to be 157.5. Every time 5 centimeters go up. 0.5 centimeters. Yes. Asha. By an order dated August 16, 2023. This court directed the superintendent, Eastern Command Hospital to have the height of the petitioner admeasured and answer the issue whether the petitioner was medically boldly fit for being considered for the post, for recruitment to the post for which she appeared in the staff selection commission, in the examination, in the staff selection commission's examination, 2022. Full stop. From a report dated September 22, 2023, issued by the President, Medical Board for the Commandant, the petitioner has been declared to be fit boldly in terms of height. Full stop. It has been held that the petitioner's height is 157.5 centimeters, whereas the requirement is 157 centimeters. Full stop. Next. Therefore, this court directs the petitioner to be considered for recruitment by the authorities concerned in the 2022 examination, comma, upon compliance of all the formalities, full stop. Next, with the directions aforesaid, WPA 16577 of 2023 is disposed of. Server copy certified from.
In respect of these batches of candidates, Lordship, we have the DME is completed, the detailed medical examinations are completed and results are published, Lordship. So this has to be, I mean, she can't be taken with the general set of candidates. That part is completed already.
No, the court was in season of the matter.
Yes.
This court, you have to consider her. Now, this court has directed this. It is submitted by Mrs. Alam appearing for Union of India.
Then we have to consider it in seclusion because she'll have to appear for the other tests.
No, that the DME, it is the DME's result and the RME's result that has been challenged.
No, it's
That the selection process of the candidates in terms of medical fitness is already concluded, full stop. Next. This court directs that since the court was in season of the matter, when the selection process was going on, comma, the petitioner's candidature for recruitment has to be considered in accordance with law. Full stop. That with the directions of
then we'll have to conduct the DME and all the other tests, the running, the PET,
the
whatever.
DME has the DME already. It is the PST.
This is the PET, Lordship. This
Yes, I have said that
we'll have to.
in compliance with the formalities. That's why I have directed. If the person is not successful, the person is not successful. If otherwise eligible, you will consider.
Definitely.
I am not saying that you will deviate from your norms.
61 is identical matter.
Now it is even more, 158. From 157.5, it is now measured as 158. There's a lot of difference between 156.5 and 158. How have they measured that person as 156.5? Maybe not so much difference between 156.5 and 157, but 156.5 and 158. The সবকিছুই same হবে, the reported date টাও same. এটা 157.5 এর জায়গায় 158. ওখানে তো বলেছিলাম upon compliance of all the formalities বলেছি তো। আপনি একটা করে আগে দেখিয়ে দেন। হ্যাঁ, না আমি বলছি আপনি একটা করে আগে দেখিয়ে নেবেন, একটা কারেকশন করে দিই তারপর সেকেন্ডটা করবেন।
I am for the disability.
I am for the petitioner, my lord.
You have the guy to file a report. But this is the report.
My client is not aged person. He could not come. I pay for only 1 day extension to file the exception.
I have sub copy of the report. Page 3, last quote, sir.
All right, Ashun. Report on affidavit as handed over in court today is retained with the records. Full stop. Next. Exception, comma, if any, by October 13, comma, 2023. Full stop. Next. Matter to appear for further consideration under the same heading motion on December 4, comma, 2023. Bold.
Yes.
Server.
I get. Good. Yeah.
Yeah, अच्छा, other side. Huh? Yeah, Rajman.
I beg to appear for the petition. On last.
Now here the senior, junior, both are not here. Just now the junior was here. Now both are not here.
A copy of the report has been served upon me, although he has not, possibly not filed before my lord.
You have made your exception, prepared your exception.
No, my lord, principally the finance department has agreed that the tenure of service should be extended in terms of the notification 9008 11 September 2011. But concealing the facts, not considering the facts, the subsequent notification that was issued in the year 2019, my lord, 2019, modification of the parent notification, wherein it has been admitted that less than 5 years they will kindly have
the benefits.
Benefits. If my lord so pleases to adjourn that not to pass any order in absence of Mr. Rai Mukherjee, my lord may. And if my lord so pleases to hear me, I ready to argue.
I usually don't pass orders if the parties are not present, because there's no point in passing ex parte orders, because on that ground, again, that's a ground for challenge.
Certainly.
So the petitioner is put to more difficulty at the end of the day.
Then kindly take it up not tomorrow, my lord. Fairly at the top of the list.
Tomorrow? Not today. I'm just making it not today.
Not today.
Ashun, একটা now record করুন. The state respondents are not represented today. No accommodation is also.
I informed him just at 2 p.m. Indranath Mitra.
However, in the interest of justice, this matter is adjourned. Full stop. Next, let the matter come up for further consideration on October 3, 2023. Bold. Server copy.
Tomorrow?
No. Yes, actually, if I make it not today also, it will appear on third.
Mild.
'64, my lord, for the petitioner, my lord, led by Mr. Samuel Bari, my lord. My lord, last occasion, your lordship directed the state to file and report, my lord.
My lord, regrettably, the report has not reached me from the district. I am praying for not this week, my lord, an earnest prayer to accommodate me.
How long will you require?
My lord, 1 week,
Asha?
just not this week.
Time to file report on affidavit is extended till
State.
October 6,
Yeah.
2023. Stop. Exception, if any, by October 19, 2023. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on November 30, 2023. Server copy. Bolded for this.
Much obliged, your lordship. Gratefully, Lord.
Where were you when item 63 was called on? I had to adjourn it because you are not here.
My lord, I'm for the extension. My lord, I'm seeking 4-week extension of time for filing the report, my lord.
4 weeks extension.
My lord, some of the documents are lying in the office of the Jammu and Kashmir lordship. From there, we have to take, and that has not been reached yet, your lordship. That is why I'm praying for 4 weeks extension of time, my lord.
My lord, respondent also, my lord, violated your lordship's order, my lord. My lord, your lordship directed to pay 50% of the, my lord, the salary, my lord. My lord, petitioner, my lord, admittedly, my lord, received last salary, my lord, 81,231.
Yes.
And my lord, last, my lord, they refixed. We challenged the refixation, and that is, my lord, under dispute before your lordship. Now, my lord, they started to, my lord, pay 50% of the, my lord, only, my lord, refixed salary. My lord, refixed salary under your lordship challenge before your lordship, and without leave of your lordship, my lord, how can they, my lord, implement the refixation? My lord, they should, my lord, pay, my lord, my salary as per your lordship direction, my lord, the aggregating rupees 81,231. That is page 2 of your lordship's earlier order. And they also need not pay the area also, entire area also. Only they paid 64,885. Yeah, 64,208.
Asha. By an order dated August 16, 2023, this court directed a report on affidavit to be filed within 3 weeks from date. Full stop. Such period expired on September 6, 2023. Full stop. Now it is submitted on behalf of FCI that further 4 weeks extension is required for filing of such report on affidavit. Full stop. Next. Mr. De, learned counsel appearing on behalf of the petitioner submits that 50% of gross earnings of the petitioner has not been paid to him from September 1, 2023. Full stop. The gross earnings of the petitioner was fees 81,231. Full stop. Arbitrarily, from the month of June 2023, FCI sought to illegally and arbitrarily deduct the entire gross pay of the petitioner. Full stop. The areas of pay that the petitioner was entitled to, the areas of 50% of the pay that the petitioner was entitled to from June 2023 in terms of the order dated August 16, 2023 has also not been disbursed to the petitioner by September 16, 2023. Full stop. Next. In view of the rival submissions of the parties, this court directs the areas of pay from June 2023 till September 2023 to be immediately disbursed to the petitioner, not later than a period of 2 weeks from date, taking the gross pay of the petitioner to be rupees 81,231, full stop. Next. Furthermore, the petitioner will be paid 50% of the gross pay of rupees 81,231, month by month, full stop. Month by month in compliance of the order dated August 16, 2023, full stop. Next. Time to file report on affidavit is extended till October 19, 2023, full stop. Exception, if any, by November 30, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 4, 2023. Server copy.
Great much.
Sorry, madam. This is not the time.
My lord, Mr. Asim Kumar Ganguly appearing for the state in this matter, my lord. He is on leg in court number 654. Therefore, I prayed not today.
Not today.
Your lordship, I appear on behalf of the petitioner, your lordship. This is the matter pertaining to the Coal India employee, where his effective notional seniority was not given since E6 grade. Your lordship, the Coal India has filed his report, and I have filed my exception. Your lordship, if your lordship permits, I shall show certain paragraphs of the report where the Coal India specifically admits my case made out in the writ petition, your lordship. Your lordship will kindly take the report filed by the Coal India Limited. The first page, comments of CIL Executive Establishment Department, your lordship.
Lord, before that, my lord, if your lordship kindly allow me.
1 second.
Page number 3, your lordship.
15 September 2023.
Yes, your lordship. Your lordship, it's the first enclosure, your lordship.
Yes, 1 second.
My lord, the petitioner has approached this honorable court with unclean hands and my lord suppressed the material fact. Kindly see for a moment page 14. Page 19. Page 19.
Page 19 of the?
Of the, my lord, my report on affidavit.
Yes.
His case is from E5 to E6. And on the basis of this document, your lordship would be satisfied that they have suppress the material facts. And they are not entitled to any equitable relief before this honorable court.
Your Lordship will kindly look at the,
All right.
Your Lordship will kindly look at the date of the letter, 25th January 2019, Your Lordship. Your Lordship, this is an irrelevant fact. To the extent Your Lordship will kindly come to the report first. Your Lordship, kindly allow me to place the report. Which is paragraph say 3, they mention that as per the prevailing mining career growth, such and such, dated 12 June 2006, executives who pass first class FMCC in E3, E4 and E5 grade will be horizontally placed in the same grade in mining first class channel from the effective date of first class. Accordingly, he has been horizontally placed in E4 grade of the mining second class channel with effect from 3rd July 2008, wide an order dated 7/6/2010. Your Lordship, kindly note this date. Your Lordship, paragraph 5, in paragraph 5, they admit that in the meanwhile, Shri Taposh Rai has been superseded by his juniors who did not have first class MMCC, but got promoted to E5 grade in the second class channel. Here they admit that the first class, the Taposh Rai had been superseded, Your Lordship. The point at which I was given the notional seniority was after my juniors had been promoted to the E5 grade. Firstly.
No, one thing you have to clarify is that suppose you are given a promotion and you do not accept the same.
Your Lordship,
then what
that is a, Your Lordship, that came, Your Lordship, that is also, I shall answer Your Lordship after Your Lordship considers paragraph 8 of the report. Before that, Your Lordship, they have referred to the High Court's order, which had been passed in my earlier writ petition. The order was passed in 13 March 2012. Sorry, 12th March 2012. Whereas,
second, give me 1 second.
Your Lordship, paragraph 6 and 7. With a regulation number 25.
My Lord, I would request your Lordship to read
Your
the
Lordship, kindly may
report
I
as
be
a whole.
allowed to.
I shall 1 second. Today you are aggrieved by the fact that your juniors superseded you in 2010.
Your Lordship, my juniors have been superseding me. These juniors have superseded me since E4 grade, Your Lordship.
Yes, since 2010. Since
Your Lordship,
February
2010.
Yes.
Your Lordship, in 2010, I had filed a writ petition
petition.
where directions were passed to recast my seniority in
Yes.
terms of the regulations of 2000, Your Lordship. Despite there being an order in 2012, the order was complied or sought to be purportedly complied only in 2017, by which time my juniors had further been promoted to E6 grade. Your Lordship, and that has been admitted in paragraph 8 of the report. Your Lordship, may I read paragraph 8? As per the revised E5
1 second. So there are two supersessions by your juniors, once
Yes.
in 2010 and once in 2017.
Yes, Your
And
Lordship.
then in 2019, you have
Your
been
Lordship,
offered-
2019, Your Lordship, may I indicate, Your Lordship. It is admitted that provided my notional seniority was given on time, my seniority would have been fixed at the particular time I was eligible to. I would have been I was eligible for the DPC cutoff date of 30th June 2016. It is admitted by Coal India.
Yes.
But I couldn't appear in the said DPC because of the fault of the Coal India Limited, where they admit Sri Taposh Rai and 3 others were not considered in the said DPC because the notional seniority was given only after the issuance of the promotion order of 20th February 2017. After my juniors had been promoted, I was given that notional seniority. If I was promoted to E5 grade in 2013, Your Lordship, in terms of the High Court's order, as well as in terms of the 2000 regulation, which clearly indicates that an executive, after being promoted to E5 grade, his seniority has to be recast in primarily the officer who passed first class MMCC has to be placed earlier in the seniority list. Your Lordship, I was made to lose out the opportunity to appear in the DPC of 30th September 2016, where the parameters of consideration were also different. Your Lordship, subsequently, in a subsequent DPC, Your Lordship, I was promoted where I had raised an objection letter, which is a part of the writ petition, Your Lordship. There, the refusal comes, Your Lordship. If I would have been allowed to participate in the DPC, now what Coal India is trying to do is, Your Lordship, since 2010, they have been depriving me of my seniority. Now, indicating an irrelevant subsequent fact, they are trying to curb my seniority and refusing to give me my notional seniority. Your Lordship, this is a case made out only in the report, and such facts have not been revealed to the petitioner earlier anywhere else, Your Lordship. This is a new case being made out before this court, Your Lordship.
The petitioner did not know that he has foregone his.
Your Lordship, Your Lordship, that is a subsequent DPC, Your Lordship. I was eligible for 2016 DPC.
What prevented you from bringing it on record?
Your Lordship, that the promotion, I had got promotion and I had made an objection, Your Lordship.
What prevented you from bringing this refusal on record?
Your Lordship will kindly come to page P15, page 92. This was my objection before Your Lordship, Your Lord. Before the CIL, Your Lordship. Your Lordship, I have indicated that I had got promotion and I had been, I had written an objection note. Thereby, I had been indicated that unless I join, my promotion shall be cancelled, Your Lordship. That I have mentioned in the writ petition, Your Lordship. Thereafter, this notice, due to personal that situation, this notice was issued, Your Lordship, this letter. But this, Your Lordship, is an irrelevant situation where I was.
That might be an irrelevant situation. Why did you not bring it on record?
Your Lordship, that this letter, I didn't have a copy. This was a copy submitted to the Coal India Limited. Your Lordship, my objection has been submitted, Your Lordship. And Your Lordship, I have mentioned it in the writ petition that I had got a promotion and had objected to such promotion because notional seniority was not given to me. That I have mentioned in the writ petition, Your Lordship.
Not in the pleading.
Where have you said that you got a promotion?
Your Lordship, I shall indicate.
And you have foregone it?
Your Lordship, I shall indicate. No, your career has been for the promotion order to the
Where is this letter?
Your Lordship, the letter indicates, Your
Where is
Lordship.
this
I have
letter
been
dated-
promoted to the
Where
post
is
of
this
senior.
letter dated December 31, 2019? Where is this letter?
Your Lordship will kindly come to page 92, Your Lordship. The letter clearly says, I have been promoted to the post of senior manager, E6 grade. Your Lordship, the letter has been annexed in the writ petition, Your Lordship. Your Lordship, on 8th February 2019, Your Lordship, page 93. I like to inform you that I had represented on such and such, which was received by Coal India. I was humbly requested that my promotion might be regularized as per the relevant rules. I might be allowed to continue with promotion from E6, E5 to E6.
So where are you saying that you have foregone your promotion? Where are you saying
Your Lordship,
that?
Your Lordship, this refers to the 1st January 2019 letter that was made to be written by me. Thereafter, I had written to the Coal India
1st
Limited.
January, where does it refer to? 1st January?
5th January, Your Lordship, page 93. Your Lordship will kindly come to page 93.
5th January, where is 5th January's letter? I do
Your
not
Lordship,
see
page
5th January's
92.
letter.
Page 92. Your Lordship, the letter doesn't say I have foregone the promotion, Your Lordship. But after
So
this
how
letter,
do I know that you have referred to your letter dated January 25, 2019? From where do I get that? Because 5th January's letter has to be before 25th January's letter.
yes, Your Lordship.
So how can you take into consideration the letter that you have written on 25th January by 5th January's letter?
Your Lordship, in February also I have written.
So where have you referred to January's letter?
Your
On
Lordship,
8th
this
of
was-
February?
And that too, he was unsuccessful in the DPC. Nothing was pleaded.
Your Lordship, I was unsuccessful in the subsequent DPC where.
Now you tell me, where have you said that you have foregone your promotion?
No, Your Lordship, I have not mentioned. Your Lordship, I have admitted that I have been promoted and I had agitated against the fact that even after promotion, my notional
Your
seniority has not been
agitation,
given.
I have understood. Now,
But this letter has not been annexed because this letter was admittedly not available with the petitioner
and you
during.
could not plead also.
Your Lordship, this was not in.
Now they have cancelled it on 31st of January. You have said, ask them to cancel it by letter dated 25th January, and then they have cancelled it on 31st January 2019.
Your Lordship, on subsequent to this, Your Lordship, I had written to the Coal India
second.
Limited.
Now you please
On
show
February.
me when have you given him the promotion? From when, with effect from when? Where is your letter? Office order granting
My
promotion.
lord, the promotion right from, my lord, if we consider that when they have raised their grievance before the honorable court, my lord, that his juniors,
Ask for you to cancel it. Now you tell me from when did you
my lord,
give
that I am submitting, my lord, their grievance started before the honorable court. When they have the grievance, the juniors have, though who have not acquired FMCC, got promoted in ES grade in mining 2 CL channel by order dated 15/2/2010. To address the same in the High Court, order dated 12/3/2012, which is annexure P7 in the writ petition, my lord.
Sir,
In the matter of writ petition
I'm
number,
sorry, you are not answering my query.
my lord, I am submitting that. I am submitting
Please
that.
show me.
In
Just
spite
kindly
of
come-
not completing the minimum residency period of 3 years, this concession and relaxation was given only by dint of the honorable court's order. That is, my lord, from 3/7/2008, CIL has revised the deemed date that of ES grade of Sri Tapos Rai along with 3 other similarly placed executives or to 15/2/2010 by order number 118 dated 21/9/2007. That is, my lord, they are in their annexure P10 from the earlier date, that is 7/1/2013.
I'm sorry, sir, you are not answering my query. Please look at your report, page 15.
My lord,
Now, from when is
every development has been, my lord, given, mentioned in this
order that you have annexed at page 15 of your report effective?
page 15 of my report?
Yes.
My lord, if your lordship kindly turn to page 6, annexure A.
Please look at page 15 of your report and
Fine.
please answer from when is this order effective?
My lord, it was mentioned that this order was issued on 31st/12/2018.
From when is it effective? From 2018 December?
My lord, it was mentioned the following managers, mining in ES grade are hereby promoted to the post of senior manager, mining to E6 grade in the first class channel in the scale of pay rupees so and so and posted as such in the company indicated against their name till further orders. My lord, then my lord, after the list on promotion, the above executives will be on probation for a period of 1 year at the first instance. The promotion will be effected on and from the date the above executives report to respective company on transfer and actually assume charge of the higher post.
See, so it has to be from December 2018.
Yes.
Now his claim is that you should have considered him from 2017.
No, my lord, in 18, my lord, when his name appeared in the list, my lord, he forego his, my lord, because he was.
So today he is not agitating that. He is agitating in your inaction in terms of the order passed by an honorable coordinate bench. If you would have given effect to that order, he would have been.
We have given effect, and he is claiming, my lord, I am submitting before your lordship, paragraph 10. Paragraph 10. My lord, the petitioner got FMCC certificate from DGMS only in November 2009. Annexure P3 of the writ petition with effective from 3/7/2008. As per prevailing mining policy dated 12/6/2006, that is Annexure P2, he has been horizontally placed in E4 grade in mining 1 CL channel with effect from FMCC. Effective date is 3/7/2008 by order number 87 dated 7/6/2010. That is P4 in the writ petition. And my lord, as such, the contention of the petitioner that is horizontal movement stalled is beyond reason. Then, my lord, as explained in preceding paras on submission of FMCC certificate around November 2009, the petitioner has been horizontally placed in mining 1 CL channel promptly without any delay on 7/6/2010. That is the FMCC date 3/7/2008. In the meanwhile, as his juniors who have not acquired FMCC got promoted to E5 grade.
1 second.
Yeah.
Please look at page 6 of the report.
Yes, your lordship. 7 June 2000.
Page 6 of the report.
Your lordship, my pages now, the report is not paginated in my. Your lordship, 7 June
2010.
Your lordship,
So you have been placed with effect from July 3,
yes, your
2008.
lordship. Yes, your lordship. The order was passed in June 2010.
Yes.
With effect from 3rd July 2008.
Yes.
By which time, your lordship, the juniors who had passed first class MMCC later than me had already been promoted, which has been admitted in paragraph 3 of the report. Your lordship will kindly come to paragraph 3 of the report. Your lordship, in the meanwhile, Sri Tapo 5, your lordship, paragraph 5. In the meanwhile, Sri Taposh Rai has been superseded by his juniors who did not have first class MMCC but got promotion to E5 grade, your lordship. Your lordship, secondly, it is the submission of the Coal India Limited that in pursuant to the direction of the High Court, Honorable High Court, despite of not completing minimum residency period, they have given us a relaxation. Your lordship will kindly come to page 28 of the writ petition, your lordship. I shall kindly come to page 20.
Please let me read the report first, because jumping from here there, because on the last occasion your submission was that you should have been given it.
Absolutely, your lordship.
The effect should have been given from 3rd
But
July.
it was not effective, your lordship.
Now they produce a circular saying that you have been given effect. It has been given effect
Your
from
lordship.
July 3, 2008.
Your lordship, my submission before the court was the effective notional seniority was not given to me. By the time the notional seniorities were given to me, the juniors had already been promoted further.
because he has foregone the.
Your Lordship,
my lord,
that time
That
the
is much later,
my
sir.
lord, not only that, in the DPC, my lord, consecutive DPC, my lord, he couldn't succeed.
Your Lordship will kindly read paragraph 7 and
So
paragraph
promotion
8, Your
cannot be
Lordship.
claimed, my lord, as a matter of
The
right.
report.
And he has not even pleaded that in the consecutive DPC, he has failed. He has not achieved the, my lord, desired, my lord, degradation. From paragraph 8 to onwards, my lord, everything has been
Your Lordship, kindly
in
read
details, my lord, it has been depicted.
specifically paragraph 8. Your Lordship, may I read it out for Your Lordship?
No. So why is this anomaly? Why is this anomaly? Why were the juniors given notional seniority before the seniors? Paragraph 8 of your report.
My lord, there were two channels, my lord.
Yes.
There were two channels, my lord. Here, when the petitioner, my lord, has forego his, my lord, the
Don't bring that into effect because that is in 2019.
my
You
lord,
please
that is
explain
a matter of 18. Letter was issued in 2019.
No, the letter was issued, the order was issued in 2017.
And that is why, my lord, from 18
So
onwards.
you cannot bring a subsequent event of 2019 to explain an act of 2017, can you?
Your Lordship, in the event, may I
My
indicate
lord,
by page
he was
28?
promoted to
Let him
E2
satisfy.
5 channel, my lord, prior to them. By dint of the
You are
honorable court's
yourself
order.
admitting that the juniors were had superseded.
Superseded because of the fact, my lord, by horizontal, my lord.
Yes, that is with effect from 2008.
My lord, my lord.
Then how can the juniors supersede?
My lord, the juniors.
How is it possible?
The juniors were super because it cannot be. It cannot. My lord, the institution cannot run in a situation, my lord, that the candidate who has approached this honorable court, my lord, suppressing so many material facts.
What so many material facts, sir?
Material facts that he has appeared before the DPC. He has. In which year it is mentioned, your lordship.
Sure.
Lord, kindly I am showing from paragraph 9. In the subsequent DPC cutoff 30th 9/2017.
Yes,
which was
why
held,
this is not
which was held on 27/2/2018.
Yes.
The Tapas
So we
Rai
are
has
not
been
concerned with
considered
that.
as per refix
Mr.
seniority.
Ray, we are not concerned with that. We are considering the issue much prior to that.
My lord.
We are considering the issue from
My lord,
2008
prior to
onwards.
that, he was given notional benefit up to E5 grade.
Yes.
And
had you given him the benefit in the E5 grade?
Yes,
on
notional
the
benefit has been given.
We both can't speak at the same time. You have to understand the issue raised by the court. The issue is, why have you not given him the benefits on the day you have given his juniors the benefit?
Well,
why did you allow his juniors to supersede after the 2013 order?
Well,
That is the
was not the case, because if your lordship kindly see, my lord, it was effected from the same day.
Will you please give me a list of dates?
My lord,
Please
I
make
can-
a list
I
of
can-
dates.
I can
Because
assist
you
your
cannot take into the
I can
into
assist
account.
your lordship with a list of dates. My lord, that would be better for understanding.
You cannot take into account the events that happened in 2018 and 2019
My lord.
to explain your conduct of 2016 and 17. That
can
cannot
give a
be done.
list of dates, my lord. If your lordship kindly
And
allows.
you will have to explain why the juniors superseded.
No, my lord.
Junior
They-
executives superseded.
Lord, according to my lord, the respondents, they were not superseded. Though it has,
Said in your
my
report
lord,
that
the
they are-
date of my lord promotion was given from the same date. From the same date.
Yes, but
Because
you have
after the
issued,
Honorable
you
High
have
Court's
issued
order-
the order much later in 2016. If you give effect to an order passed by this High Court on 2013, in
My lord,
2016.
that was an issue which was decided and which was acted upon. This is an issue from E5 to E6. And from E5 to E6, what happened? That has been explained in my report, my lord, which your lordship desires to place before your lordship. And that is there, and that they have suppressed. Why from E5 to E6 was not given?
Yes, in 2019, if he writes a letter that is a cause
It
for.
starts from 2018.
You will actually not let the court speak. Yes.
Your Lordship kindly comes to page 28 of the writ petition, Your Lordship. Your Lordship, in the report, they say, in spite of the fact that I have not completed minimum residency period, I have been given a concession, Your Lordship. Your Lordship will kindly see the notional seniority in E5 grade was given to me from the date of 15th February 2010, only in 2017. Whereas what the regulation or the guidelines, promotional guidelines of Coal India indicates. Your Lordship, page 28. This is a typed copy, Your Lordship. Since it's an old policy, Your Lordship. Page 28, second para. Your Lordship, after promoting or placing the officer in E5 grade seniority, in E5 grade of all the officers in the grade is to be refixed in the following manner. The officers who passed first class earlier to be placed higher, effective date of certificate to act as first class manager as indicated under the certificate issued by DGMS should be determining date of fixation of such seniority. Your Lordship, even in the second thought, Your Lordship, after being promoted to E5 grade in the first class channel, in terms of the 2000 policy, the Coal India was duty bound to immediately refix my seniority in accordance with the effective date of my first class MMCC certificate, which was July 2008, Your Lordship. That was not done, Your Lordship. I had to approach the court. Your Lordship, the court's order was passed in 2012 and it was given effect in 2007, admittedly after my juniors had been promoted, Your Lordship. And despite being admitted that I was eligible for the 2016 DPC, I had to miss out on that opportunity, Your Lordship, due to the fault of Coal India Limited. Where the criteria for considerations had also been different in 2016, because, Your Lordship, in DPC, the three ultimate years EER is considered, Your Lordship. So once I miss out on one opportunity, 1 year opportunity, Your Lordship, then those criteria are no more relevant in subsequent DPCs, Your Lordship.
Lord, he is harping on the policy of 2000.
Your Lordship, which is
That
applicable
was
on the petition.
repealed by the, my lord, 2006.
Your Lordship, that was an modification of the order only to the extent of E2, E3, and E4 grade. Your Lordship will kindly see the 2006 policy, page 29.
And FMCC he got in 2008. And the policy which was applicable in 2006. But his whole case stands in the
Your
policy
Lordship,
of
2000 policy and 2006 policy was applicable on the executive date, as on date, even in till E5 grade, Your Lordship. Proper instructions need to. Thank you.
My lord, kindly consider from paragraph 10 of my report, my lord. If your lords, you allow me to submit.
Asha. The report on affidavit and exception thereto, as handed over in court today, is retained with the records. Full stop. From the report on affidavit at an extract, it appears that The petitioner was appointed in E2 grade in second class channel with effect from October 3, 1994. Second class channel of the executives of Coal India. Full stop. He was subsequently promoted to E3 grade within bracket new E4 bracket closed in the second class channel with effect from September 15, 1998. Full stop. While working in E4 grade, the petitioner acquired the certificate for first class mine managers within bracket FMCC with effect from July 3, 2008. Certificate of competency. Competency. Next. According to the policy of the Coal India, intimated video office memorandum dated June 12, 2006, the executives who pass first class MMCC in E3, E4 and E5 grade were required to be placed horizontally in the same grade with the executives in the first class channel. Full stop. Such recommendation came into force with effect from May 8, 2006. Full stop. The effective date of putting the executives horizontally, placing the executives horizontally in the first class channel would be the date on acquiring the first class FMCC. Full stop. By an order dated June 7, 2010, the petitioner was placed horizontally with the executives in the first class channel in E4 with effect from July 3, 2008 within bracket date of passing of the date of the said certificate of competency. Bracket closed, full stop. Next, as per the prevailing policy, the petitioner is required to complete minimum 3 years of residency period in E4 grade in first class channel, before he can be promoted from E4 to E5 grade Full stop. From the report, it appears that the petitioner has been promoted from E4 to E5 grade with by an order dated January 7, 2013. Full stop. However, it has not been explained why the petitioner was superseded by his juniors, who did not have FMCC but got promoted to E5 grade, before the petitioner. Full stop. Next. Since the petitioner was superseded by his juniors, he moved a previous writ petition being WP number 22887 of 2010. Full stop. By an order dated March 12, 2012, a coordinate bench of this honorable court held that a global seniority list of all the incumbents should be prepared on the basis of the dates on which first class MMCC were granted to the petitioners in the previous writ petition. Full stop. After preparation of such global seniority list, the incumbents should be considered for promotion to the next higher grade. Full stop. Next. It is the case of CIL that despite not completing the minimum residency period of 3 years in E4 grade, with effect from July 3, 2008, the petitioner was placed along with other executives in E5 grade from February 15, 2010, with a order dated September 21, 2017. Full stop. Why the said order dated March 12, 2012 was given effect to on September 21, 2017 has not been explained in the said report. Full stop. It has also not been explained why, despite the order dated March 12, 2012, the petitioner's position was not restored in the global seniority list, even after promotion on January 30, 2013. Full stop. Next, the global promotion list was published on January 30, 2013. But CIL, Coal India Limited, sought to implement the order dated March 12, 2012 on September 21, 2017. Full stop. By the order dated September 21, 2017, the petitioner was sought to be given notional seniority from February 15, 2010. Full stop. However, why the petitioner's valuable right of being placed in the global seniority list of 2013 was not taken into consideration by the CIL has not been explained in the said report. Full stop. It has only been stated that the notional seniority to the petitioner was given in E5 grade with effect from February 15, 2010, V-Day order dated September 21, 2017. Full stop. Next. Then the report proceeds to say, state that the cutoff date for DPC was September 30, 2016 for consideration of the promotion from E5 to E6 grade. Full stop. Such promotion was given after the DPC was held on September 30, 2016. V-Day order dated February 20, 2017, whereby the juniors of the petitioner were promoted to E6 grade. Full stop. Next. Why the petitioner was not given the benefits of the order dated March 12, 2012 in the DPC that was held on September 13, 2016 has not been clarified in the said report. Full stop. It has been boldly stated that the notional seniority was given only after issuance of the promotion order dated February 2017. And since the petitioner was lower in seniority position, he was not considered in the DPC of September 30, 2016. Why such an arbitrary and high-handed action was taken by CIL even after the order passed in March 2012 has not been commented upon. Full stop. Next. It has been further stated that a subsequent DPC was held on September 30, 2017, which was finally held on February 19/27, 2018. Full stop. February 19/27, 2018. Full stop. The seniority of the petitioner was refixed on the basis of his notional seniority in the E5 grade with effect from February 15, 2010. As per the provisional seniority list dated February 1, 2018. Full stop. Why the provisional seniority list was not published? Now, why the petitioner's name did not feature in the global seniority list of 2013 does not find any mention is also not explained. Therefore, the statement that the petitioner's seniority has not been fixed as per the Honorable High Court's order dated March 12, 2012 does not have any merit, cannot be accepted by this court. Full stop. Next. Now it has been submitted by ECL that the petitioner has himself refused promotion by a letter dated January 25, 2019. Full stop. Since that letter was not brought on record in the present writ petition, the petitioner has suppressed material facts before this court. Full stop. Next. With due respect to the learned advocate appearing for CIL, this court cannot accept such submissions because it has not been explained why the petitioner was not considered for promotion to E6 grade in the DPC that was held on September 30, 2016. Full stop. The delay and the latches remain completely on the part of CIL, remain completely unexplained. Full stop. Next. Let an additional report on affidavit be filed by CIL, taking into account the observations made by this court and explaining the delay and latches, which prima facie to the mind of this court is deliberate and willful, comma, be filed by October 13, 2023, full stop. Exception, if any, by November 24, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on November 30, 2023. Serve a copy.